Officer? Court officer? ಹಲೋ. ಗುಡ್ ಮಾರ್ನಿಂಗ್. ನಿಂದು ನೀನು ವಾಟ್ಸಪ್ ನೋಡಿದೆ, ಫೈಲ್ ತೆಗ್ದಿದ್ದೀನಿ, ನೋಡ್ಬಿಟ್ಟು ನಿಮಗೆ ಅದೊಂದು ಮೇಲ್
When did you file this?
Yesterday, my notes.
If the office of objections or complaint, it will come tomorrow.
Complete my notes. Anything is said tomorrow, my notes.
If the office of objections or complaint, let it come tomorrow. Yes.
Release of 2019, my lords. Release of 2019.
ನಾಗರಾಜ್
ಸರ್ ಈಗ ಬರ್ತಾ ಇಲ್ಲ.
ಯಾವಾಗ ಬರ್ತಾರಂತೆ?
ಬಂದಿದ್ದಾರೆ ಸರ್.
ಬಂದಿದ್ದಾರಾ?
ಬಂದಿದ್ದಾರೆ ಆದ್ರೆ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಸರಿ,
Proceedings ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ಓಕೆ.
The appellant.
Yes.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ನೆಟ್ವರ್ಕ್ ಸರಿ ಇಲ್ಲ ನೋಡಿ.
ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಾಣ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಾಣ್ತಾ ಇಲ್ಲ.
Video and audio both.
Four minutes.
62873, serial number 4, 8 number 4, serial number 9 to 14.
Number 12, my lord. I am for respondent in this case, my lord. I am informed to others also, my lord. Upon 15th, my lord, in Delhi, my lord. I am informed to others also. My lord.
You are for the petitioner.
But appellant, my lord, respondent, my lord, in this case.
Petitioner.
I file objections also, my lord. Take up on 20th, my lord, I argue the matter, my
They are having stay.
lord. 20th, my lord.
They are having stay.
No, my lord. There no in admission, my lord. I file objections also, my lord.
In that case, we will hear it. This is matter on twelfth March. Serial number 14.
One is one submission.
For the respondent.
One submission. 12th, not in station, in 1 week, my lord. That also is a request, my lord.
What is
15th,
today's date?
15th or 16th, my lord.
What is not able to understand?
File the
This is not
objections.
17th.
Much obligation.
Your Lordship, serial number 14, Your Lordship, I will appear for respondent.
Hmm?
Serial number 14, Your Lordship, appear for respondent. I have From the petitioner counsel, there is a stay. Stay may be kindly extended and need a week's accommodation. We have filed the objection. I have to place one more document on the record. I've already informed the other side, Your Lordship. And their interim order may be kindly extended, Your Lordship.
Do you feel that these matters seriously require all these kind of, adjournments? CP, unnecessarily we are staying the suit and keeping it pending for years.
I understand, Your Lordship.
No, not required.
Only a week's I have to file one more document. Last hearing date, after arguments, the Honorable Court asked me to place certain documents. I have placed it. There's one document missing, and I've requested them and I've informed them also. They told interim order may kindly extend.
I'm making it very clear, in all these CP matters, court will not adjourn. This is final adjournment.
Much of
List this matter on Tuesday, no further adjournment.
much of it.
Page number 5, serial number 15 to 20. Page 6, serial number 20.
Respondent counsel has got some slip disk problem. I have informed the other side.
Serial number
4 May.
AM Venkatesh. This is matter on Monday. At the request.
I put you muted. Proceedings are muted, my lord. Mute ಆಗಿದೆ.
She has no income and she is residing with their aged parents. She cannot travel from Malebennur to Chitradurga.
What is the distance?
150.
Any other matters pending at?
Yes, my lord, in Chitradurga, my lord, one OS 163 of 2024 is pending, my lord. She has to attend to that.
What is that OS?
OS, my lord, injunction filed by the respondent parents restraining the wife to enter into the house, my lord. It is still pending. And one more criminal petition is there, my lord, which is thus FIR is filed by the father of the respondent, my lord. It is also still pending there, my lord. She has to attend that.
Any children in the wedlock?
No, my lord.
Then what will you do with those two cases?
For Malebennur to Ariyara Taluku.
Hmm?
嗯 Chitradurga family with the Passover. Senior.
No, there are two suits, one suit is pending.
Okay, my lord, please, my lord. Total.
What is this?
Total 18.
ಸ್ವಲ್ಪ ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಮೇಡಮ್.
Is seeking passover, my lord, because
Passover. Yes, next.
CL number 2, Muralidharan for appellant, Satip Kesi.
Yes.
CB 250.
CP 250, your lordship.
2, not 3,
CL number 2,
please.
CL
But
number
I-
2, Harish Bandari,
Yes,
for
Your Lordship.
petitioner. Yes, sir, Shripad.
This is the case, your lordship, wife's petition to transfer the petition from the filed by husband in Bangalore for divorce. Where the wife has been filed the petition under restriction of conjugal rights before the Davangere. And one more petition, so the DV Act and
No, first of all, this CP 250 is filed by whom?
one CP is filed by me, your lordship.
250 is by you.
250 is
340 by
filed
me.
By you is by wife.
by wife, your lordship.
Then CP 340 is
That
by
is by
husband.
me, my lord. I am for the husband. I filed.
Wow, wife had filed for restitution.
I have filed restitution. A domestic violence is also pending before the Davangere. Then your lordship on maintenance act, under maintenance.
125 CRPC is pending.
And then domestic violence also.
Then
Then
what about, no, you have filed it Davangere.
I have filed it Davangere.
You are seeking transfer to where?
Bangalore, my lord, where I am, my lord, I have filed a petition for divorce. Not my petition, the first petition.
No, no.
Then subsequently filed on. And she is gainfully employed in Bangalore. She stays in Bangalore.
Oh.
I have records.
Where is the material to show?
Lord,
Worship.
the
In my case, your lordship, on
page number,
8/2/24, I have filed the restitution of conjugal rights before the Davangere court, your
But the
lordship.
point is, you're residing in Bangalore.
No, I was residing with the husband. Now, your lordship, because I am a software engineer.
As of now, according to them, you're gainfully employed and residing in Bangalore.
No, I am residing with Davangere.
Relying on something, we'll see.
Lord,
Where is
page
that?
number 59,
In
the
which
CP
matter?
340,
In the second matter,
please.
page number,
59, my lord. The acknowledgement, she receives it, Bangalore, where she works. It is in Bangalore.
date of,
This is much after the restitution petition. She files a restitution petition, and much after that,
it on 29/1/2024.
that is date of, Lord, date of sending the notice.
When was it received?
Maybe, Lord, 2-3 days later,
Hmm.
she receives this. Then
It's a restitution petition file.
it was,
Davangere.
it is in
That
before
is filed, your
23,
lordship.
2024,
15,
23, 2024,
that is much after this.
please.
Yeah.
And then, my lord, she gives a statement before Davangere court in a 164, under 164 CRPC, in a 498A proceedings. Before the Davangere court, she gives a statement that she is staying in Bangalore.
Take that.
But it is in Kannada, my lord, I'll just make my submission. Before the learned magistrate, my lord, she gives this statement. Name Kavya, husband's name Pritam, age 26 years. Employment engineer, place of residence Bangalore. This is before the Davangere court gives, she gives the statement, she is staying in Bangalore.
May I submit?
What is it? 1 minute. What is the date? This date is 26/2/2024.
This is 26/2, my lord, please. Lord, before the Davangere court only, she gives this statement. She says from 15/9/2023, she is staying away. She is in Davangere, 15/9/2023. That is her statement.
In this case.
Please.
Let us see that.
Please. In the restitution petition. Page 47 in my case, not.
Page 47 in your case.
340. Cause of action for the petition arisen on 18/9/23. The respondent withdraw his company by deserting the petitioner. Since then, she is staying with.
All whatever you're relying on are in the month of June, Jan and February.
Please.
So the restitution petition was filed in the month of March.
Please.
So what is her case and what is the material thereafter to show that she is residing in Bangalore?
Lord, she is employed in Bangalore, Lord. I have produced the acknowledgement. Now also she is working there.
File an affidavit.
I will also file the affidavit, my lord.
And all the details, and tell your client that any of the statements that are made before this court are not correct, will initiate perjury proceedings against her. The land counsel appearing for the husband submits that. Wife is
What
gained.
I have given understanding, Your Lordship. She was working in Bangalore and affiliate, Your Lordship, because of the
No, that's your case. That is his case.
of-
We'll
because
record
of
both.
homework. So very often she comes to Bangalore also.
Very often she comes to Bangalore,
Yeah.
she file cases at Davangere, and when already the prior case is pending here, and she want the husband to go around and come before this court seeking transfer. What is this?
No, my submission only this much, Your Lordship.
Lord, I will file affidavit.
Please wait. Yes.
What I was given to understand, Your Lordship, that she was staying with her parents now. Because it is case of her, Your Lordship, the husband left her at her parent house.
A lady who is working, why would she say when her place of work is at Bangalore?
No, place of work is Bangalore, then Your Lordship, it was work from home. Work from home provision was there. Then Your Lordship, as and when their requirement was there, Your Lordship, in the office.
Will record because her workplace is here. Let her, we will transfer the cases to, your case is also to Bangalore. Two options. Either with all this that has happened, we'll initiate proceedings against her after taking an affidavit or from you, or else if you don't want all that, we'll transfer her case to Bangalore. That's the only option. That's two options left to her. Let her choose whatever is, please get instructions. Let's just matter tomorrow.
Please.
Case number 3. Muralidharan for appellant. Latif Kesi.
Yes.
It is an injury claim. The claimant claimed to be a compressor operator. I have insurer of the tractor, my lord. As your lordship aware, compressor is different, tractor is different. I have insured only to, he was working in a remote place, that is in mines. The tractor was parked somewhere else.
No, compressor is not insured.
Not insured with us.
Tractor is carrying the compressor.
No.
No, how the compressor will work?
It is different, different engine, my lord. Compressor is different, tractor is different. Only with the vacuum, I mean, see, the engine pressure, they will get it operated to somewhere else. Because compressor is some other different, I mean, see, instrument. This tractor is
That I
different.
understood.
Yes, my lord. He was cutting the stones and in the mines. And while cutting the stone, some of the stone piece has fallen down and he sustained injuries. That is the claim of the claimant. The owner of the vehicle has appeared before the tribunal. I mean, say he is employees commissioner, compensation commissioner, and he has stated that he is a silent spectator. He was not working with him. According to him, for compressing operator, some specialization skills is required to be done, followed. He is not a such operator. There was no employer and employer relationship. That's what he has stated in his version. Para 8 of the objections filed by the owner of the vehicle.
Yes.
And during the course of cross-examination of PW1, he has stated that he has not at all seen the owner of the vehicle. And
There are two aspects now.
yes, ma'am.
One is on the liability. That that vehicle is not, that compressor, you have only insured the tractor. So you're not liable to pay the. compressor.
Yes, my lord,
So on that, we'll see what is the finding.
please.
Page number.
I request your lordship to refer para 8 of the objections filed by the respond number 1 before the tribunal, before the commissioner.
Para number 13. The second contention of the respondent number 2 also will not hold good for the reason. It is mentioned in the insurance policy, that is exhibit R2, drilling rigs attached to tractor. Therefore, second respondent has taken the premium, including compressors. Under such circumstances, the insurance company is liable to compensate the petitioner.
That finding of the tribunal is erroneous, my lord.
On what ground?
You may kindly refer the policy which has been produced by
Take
me.
that policy.
Exhibit, sir.
With R2.
Automatic. Copy ಕೊಡ್ಲಾ madam?
You pass on the copy.
ಇತ್ತ.
Take that copy.
I have insured only in respect of the track.
Because earlier, my lords, that matter was ended up in compromise. After compromise, my lords, now she started interfering with the peaceful possession of the petitioner. The petitioner herein,
According to you, interference with you is showing the land in the said suit or otherwise?
land,
Interference.
please, my lords.
Interference, you are. In what manner?
By including my property.
Only thing.
Is- Injunction could be inferred from the compromise decree. It relates only in favor of the respondents who are the plaintiffs therein. Thus, in any view, there cannot be any order or decree of injunction in favor of the petitioner who was a defendant therein. Apart from the above, when the petitioner herein who was a defendant in the said suit against whom a relief of injunction was sought had entered into a compromise, it means he or she has admitted her interference with the plaintiff and agreed title and possession of the plaintiff therein. As such, there was no decree against the plaintiff therein. That being the case, question of plaintiffs violating the decree does not arise. The petitioner also relied on the suit filed by the respondent in OS 253/12 and alleged that by filing the very suit, respondent has impliedly denied the possession and enjoyment of the property by the petitioner, which amounts to violation of the decree. But on perusal of the plaint in the said suit at Exhibit P5, it appears very clear that said suit is not filed against the present petitioner. Further, it is alleged that respondent also filed an application for amendment of plaint for including some
Yes.
extent of property.
Yes.
My lords,
What is
decree-
where is the plaint?
plaint we have not.
So then,
Decree have produced, my lords.
where is that?
Annexure A, my lords.
Page number?
Ink page,
Not the compromise decree.
please, my lords.
I'm not asking for the compromise decree. I'm asking you to show the plaint.
This, my lords, Annexure C, my lords. OS 253/12. Annexure C.
Page number.
Ink page 33, my lords. Sorry, my lords, 23. Ink page 23, Annexure C. My lords, she is the absolute owner to an extent of 3 acres, 6 quintas, my lords.
Grant, so.
Earlier, even
They showed only 3 acres, 6 quintas.
later, she filed an application seeking amendment, my
Where
lords.
is that?
Annexure D, my lords. Annexure D. Application under Order 6, Rule 17 of CPC, my lords.
Oh, you have filed a translated copy.
Please, my lords.
As per the said decree, it mentions about 3 acres, 6 guntas,
Please, my
which
lords.
is allotted to the plaintiff.
Please, my
Where is
lords.
your land?
Next, my lords.
What is the extent?
My lords, 3 acres, 6 quintas, my lords. For petitioner herein, my lords, it was allotted 1 acre, my lords.
Where do you get that?
I 235, different number 5, my lords. Para 2, my lords. Land bearing
1A
survey
means
number
1 acre.
235 to the different number 5, my lords.
No, 1A means 1 acre.
Please, my lords. 1
No,
acre in the land
no.
bearing survey
How do
number.
you say, no, what they are showing by way of this is
Please,
5 acres, 9 guntas. Even assuming that 3 acres, 6 guntas is his land,
please, my
1 acre is yours.
Please,
It
my
comes to 4 acres, 7 guntas.
please,
Then
my lords.
where from the other, there is one more acre also.
It is there, my lords. They have encroached and they are trying
So
to
whatever it
encroach.
is.
Please,
So
my lords.
from that, how can you say that there is a violation of the judgment and decree?
Because, my lords, they have included my property, my lords. They are trying to include my property. Because of that, we have filed the execution petition, my lords, and in that we have clearly stated. And she's seeking,
This decree itself is something which the court is not able to understand. That's what is the finding of the trial court also. This compromise decree is very much silent about what are the rights of the parties.
please, my lords. My lords, here it is clearly
If you have
stated,
any
my
other
lords.
remedy to implead yourself in that and to show that your land is included, do that. Please come. Agreed with orders passed in execution 3 of 2015 dated 5th August 2019. The defendant number 5,
5, my lords.
defendant number 5 is before this court. The respondent herein has filed a suit in that the petitioner herein is arrayed as a defendant number 5. Thereafter, a compromise petition is filed. Basing on that, a decree was passed. It is the case of the petitioner that the plaintiff, as per the same compromise decree, the plaintiff is entitled for an extent of 3 acres, 6 guntas, and the defendant. And there are several defendants.
Please, my lords.
And then you are the only one who has filed.
Please, my lord.
Then how can it be? There are 4 defendants.
Please, my lords.
So what is the land allotted to each defendant? And how does this decree shows all that? And it is a case of the petitioner, of the defendant, that 1 acre is allotted to the defendants. 1 acre is your defendant number 5.
Different number.
1 acre is allotted to defendant number 5. Thereafter, a suit is filed by the plaintiff therein in the earlier suit. That is OS number,
236/99, my lords.
page number,
Ink page 12, 236/99, annexure A, my lords.
page.
Ink page 12, my lords.
Present suit.
Present suit, no, 253/12, my lords. Annexure C. Annexure C, ink page 23, my lords.
Has filed OS number 253 of 2012 against a third party. And initially the extent of land is shown as 3 acres, 6 guntas. Thereafter, an application is filed under Order 6, Rule 17. Now they have amended it to 5 acres, 9 guntas. It is a contention of the land counsel for the petitioner that by including the land belonging to the petitioner, which was allotted as per the compromise decree, the present suit is filed and it amounts to violation of the judgment and decree. And accordingly, he has filed the application. That is execution number 3 of
2014, my
3
lord.
of 2014. To send him to civil prison and for attachment of mobile, immovable properties. How can he be a judgment debtor?
That there is some mistake, my lords, in the order.
The decree holder, the plaintiff who was in the compromise decree. The trial court by order impugned had expressed the same. It is stated that the petitioner herein who is the defendant is a defendant and the plaintiff has filed a suit for injunction and entered into a compromise. It means the defendant has admitted her interference with plaintiff and agreed title and portion of the plaintiff therein. The court came to the conclusion that there was no decree against the plaintiff therein. And that being the case, question of plaintiff violating the decree doesn't arise. The court also observed that there is no violation of the judgment and decree. And from the compromise decree, it is clear that the respondents, who were the plaintiffs in OS number 236 of 1999, are agreed to be in possession of 3 acres 6 kuntas in survey number, and also some more extent adjacent to it, which belong to government and for which they had applied for regularization. So it is clear that respondents were in possession of the land more than 3.6 acres, the said survey number. As such, the amendment, the claim by way of amendment in the suit appears to be in accordance with law. So there is no illegality in the claim of the said suit, and it doesn't amount to any violation of the compromise decree, and accordingly dismiss the application. And then counsel appearing for the petitioner submits that as per the compromise decree, when an extent of 1 acre land is given to the petitioner, and that land is also included after in the application that's filed under order 6/17, that amounts to violation of the judgment and decree in the earlier suit. And the court ought to have entertained the application and granted the relief as sought for. The notice is served on the respondents. No wakalat is filed. I heard the counsel for the petitioner. There is a material on record. This court has perused the compromise decree. In the compromise decree, 3 acres, 6 kuntas is shown that is granted to Mariana and Mariama, and the land attached to the said survey number, for which the plaintiff has filed an application for regularization, and the government lands which are in his illegal possession. Looking at the judgment and decree, and also the finding of the court, it appears finding of the court is clear that apart from 3.06 kuntas, there is some more land which is in possession of the of the respondent herein. The trial court had rightly observed that, apart from 3.6, some more land is in his possession. And basing on the application filed under Order 6 Rule 17 in a subsequent suit against a third party, and where a third party, it cannot be said that the respondent has violated the judgment and decree and rightly dismissed the petition. This court finds no reasons to interfere. Accordingly dismissed.
Bill number 5. For dismissal. Appellant PB Raju.
On 10/2/2025, an order is passed permitting the counsel on record to retire. And if the parties do not pursue the matter, either in person or through advocate, the matter will be dismissed. Yesterday, the matter came up before this court. And there was no representation on behalf of the parties. And the
My
counsel.
lord, if it is serial number 6, my lord, I am for the respondent.
5, ma'am.
Sorry.
What did you write? For representation on behalf of the petitioner. The matter was directed to be listed today as a capital participant. Today also, there is no representation. It is clear that the applicant is not interested to pursue the matter. Accordingly, dismissed.
Bill number 6. Satish Shetty for appellant.
Appellant, my lord. Case pass for my lord. Scenery is done.
Pass over.
Bill number 7. Umesh.
Appear for the appellant, my lord.
Connected appeal.
My lord, I prepared the my lord application for substituted service. If your lordship permit, it will be filed today, my lord.
Then counsel for the appellant submits that they have already filed, they're filing an application for substitute service of notice. List this matter on Monday.
Please.
Delete the caption for dismissal.
Bill number 8. Vishnumurthy.
Milords, I appear for the respondent in this matter, Milords.
Vedu Kumar VS.
Do that. The perusal of the proceeding shows that on several occasions, there was no representation. And in fact, on 10/2/2025, an order was passed whereby the petition was directed to serve the copy of the appeal memo on the counsel for the respondent, or else a cost of rupees 1,000 shall be paid to the advocate's liability fund. Matter came up on 5/3/2025, and even on that day also, there is no representation. As the matter is directed to be listed today under the caption for dismissal. Today also, there is no representation. Right from the beginning, it appears that the petitioner, there is the matter is not pursued accordingly for dismissal, non-prosecution. Yes, next.
Serial number 9. Manjunath ND.
The MFA is filed in the year 2017. Right from 2017, process is not paid for service of notice on the respondents. Right from 2019. Not 2019. On 7/1/2025. The court, when the matter came up on 7/1/2025, there was no representation on behalf of the appellant. Again on 5/3/2025, as there was no representation, this matter was directed to be listed today. The caption for dismissal. Today also, there is no representation. Accordingly, the matter is dismissed for non-prosecution.
Sell for order, serial number 10. Rudra Papi. Of application.
No representation for dismissal tomorrow.
Serial number 11.
Please, my lord, appearing for the appellant. My lord, one submission, my lord. Respondent number 4 is unserved, my lord. Respondent number 4 is the mother of the victim. Respondent number 1, 2, 3 are the wife and the son and daughter of the victim, my lord. Respondent number 1, 2, 3 resides with respondent number 4. Respondent number 1, 2, 3.
Where is, who? So they are not represented by advocate.
They are, my lord. They are served and they are represented, my lord.
Who is the advocate? Sharadamba.
Yes.
Where is Sharadamba?
R4 is reported to be dead, my lord, according to my information.
We are unaware of it, my lord. We are unaware of the same.
Lakshmama.
Who reported their death?
R4, my lord. Sharadamba appears for R1 and R2. R3 is minor, represented by R1. In the court list, my lord, is shown steps to be taken in respect of R4 by substituted survey. But I was informed that R4 is reported to be dead. Council has to verify and make necessary.
They submitted that that R4 is it is submitted by the counsel for the respondent that as per his instructions, R4 is no more. Learn counsel for the appellant shall verify and come up with the appropriate application list after 2 weeks. Give a date. Yes, next.
Serial number 12.
Much obliged.
Well, my lord,
Serial number
I
12.
attest to
Anil
the
Kumar.
case
92
RTC
weeks to be
respond.
granted.
Respond.
Regarding, I have to produce the proof of the age of appellant number 5. In respect of appellant number 6 and 7 has been produced. It is application file a discharge of guardianship.
The request list after 2 weeks.
Much obliged.
Serial number 13.
My lord, what happened? Serial number 12, my lord,
2 weeks.
2 weeks.
please.
Yes.
13.
For the
Get
appellant,
DT.
appeal of the respondent,
Yes,
one in
Dipal.
case of injury, my lord.
Case of
Injury, my lord.
no memo of retirement filed by advocate for respondent.
I filed
don't
power
know.
for respondent. I filed power for respondent 1 and 2, my lords. NOC work.
Oh, you filed, you're ready?
Please, please.
Yes. You're appearing for the KSRTC.
Please, my lord. Please.
Yes,
Case of injury, my lord.
case of injury.
Yes, my lord.
How much is the compensation?
Only 40,000 rupees.
You're seeking enhancement.
Yes, ma'am.
You're a third party.
Yes, ma'am. Traveling in the bus, my lord.
Hmm.
Back
Traveling
side
in
of
the
the
bus.
bus.
What are the injuries sustained? Come to that discussion.
Page number 8, judgment of the ink page,
Hmm.
page 8, my lord.
Yes,
Shifted
come
to-
to issue number 2.
Yes, ma'am.
Issue number 2.
Issue number 2. Yes.
Now you're only seeking enhancement.
Yes, ma'am.
Issue on liability.
No, ma'am.
Huh.
Liability fixed on,
Issue number 2. You have sustained 5 simple and 1 grievous injury.
first, yes, my lord. One fracture of lateral bone, my lord.
No document is produced in this regard except self-serving testimony.
X-ray-
Then how do you expect the court
X-
to grant?
X-ray shows that fracture of
How will the court will look at the X-ray?
lordship. It's not
No.
given evidence, sir.
Wound certificate.
Wound
Wound
certificate is
certi-
there, my lord.
And the doctor you have to examine. What did the wound certificate say? Get it, give that record. Exhibit P5. Not yet received. You have a copy of it
Yes, ma'am.
on pass on. Take that. What one can understand from this about your previous injury?
Mention is made. Fracture shows lateral bone.
What has happened thereafter? What is the
Thereafter,
treatment you have taken?
he is inpatient 15 days, my lordship. And
This patient was admitted with fall from moving a bus.
moving the bus, my lordship.
He was under
A door.
Under the influence of alcohol, my lords. It's a clear case of
under the
contributory negligence.
alcohol at the time of accident. You didn't see this? You didn't see this? Show it to
Exhibit
him.
P8. Exhibit P8. Discharge summary.
He was under the influence of alcohol.
This point is not through the no evidence, document evidence. my lordship.
That's your evidence, sir.
But,
That's your evidence, sir.
in cross-examination is not
Discharge summary, medical bills, prescription, scan report. You won't examine anybody. Court has granted 40,000. Good amount. Please come. Agreed with the orders passed in MBC number 63 of 2015 dated 1st April 2016. The claimant is before this court. The petitioner herein has filed a claim petition seeking compensation of an amount of rupees 6 lakhs for injuries sustained by him in the road traffic accident. It is his case that on 26 2014 at about 4 p.m., The petitioner, the appellant, not the petitioner, appellant and his son boarded the KSRTC bus at Baram Sagara to, what is that, Halekalu.
Yes, ma'am.
Petitioner was sitting on backside seat. Because of the rash and negligent driving of the driver of the bus, the petitioner fell down from the backside of the door. He sustained severe injuries, got admitted to government hospital, took treatment for 1 day. Thereafter was referred and shifted to Bapuji Hospital, Davangere. He took treatment as an inpatient for 15 days. And as per the X-ray, there is a fracture of lateral bone. And he has incurred 1 lakh towards medical expenses. And it is case that is working in agriculturist, earning rupees 6,000 per month. The tribunal has observed that the petitioner had sustained 5 simple and 1 grievous injury. But, and also he has spent huge amounts. No document is produced for all this. No document is produced except the self-serving testimony. Considering the nature of the injury sustained and treatment taken by the appellant, the court had awarded global compensation of rupees 40,000. Then counsel appearing for the petitioner, for the appellant submits that when he has filed the wound certificate to show that he has sustained 1 grievous injury and 4 simple injuries or 5 simple injuries. 5 simple injuries. Court had granted only an amount of rupees 40,000 as compensation, which is on the lower side. It is submitted that court ought to have considered the fact that he had spent substantial amounts for the medicines and the treatment, and no amount is granted in this regard. The compensation that is awarded by the court is not a reasonable compensation, and that needs to be enhanced. Then counsel appearing for the case at RTC submits that except filing the wound certificate and some medical bills, nobody is examined in support of the same. No doctor is examined. It is submitted that considering all this, the court had rightly granted the global compensation of 40,000. 40,000 and no interference is called for with the well-considered order passed for the court. Next part. I will put the counsels on either side for use of material on record. The wound certificate shows that he has sustained 1 fracture and 5 simple injuries. The court, and as rightly observed by the trial court, except filing the wound certificate and some medical bills, he has not any person from the hospital in support of his case. Under those circumstances, the court had granted a global compensation of an amount of rupees 40,000. In the considered opinion of this court, the court had rightly considered and granted compensation, and the petitioner is not entitled for any enhancement. Appellant is not entitled for any enhancement. Accordingly, appeal is just. It's next.
Number 14.
No, in this case. This 13, a memo for retirement. In that he is permitted to retire. Who is his name? What is the name?
That is Mithun Kumar. Mithun Kumar. YG Mithun Kumar has filed.
In this place, YG Mithun Kumar has filed the registry to reflect the name of Mr. Mithun Kumar for respondent.
My lord, I am for appellant, my lord.
Yes,
Mr. The copy has to file the wakalat.
14 is the man.
14 is not list 114, sir.
Yes, 14.
DS L. Shrikant Rao.
No representation. Post for dismissal tomorrow. Yes,
Cell number
15.
15.
Yes, Mr.
My lord, I
Shastri.
am for appellant, my lord, claimant's appeal. My lord, I served the copy on.
Non-filing of wakalat by A.M. Venkatesh.
Copy is yet to serve, my lordship.
No, copy served. I have proof, my lord. On 15, 2 times I served. On 15/1/2025, I am ready to serve again, my lord. 2 times already.
In a
So
week.
how long this will go on? You serve, he again, and you will again serve.
No, let him serve, my lord. In a week's
Just-
time, I will file wakalat. Matter may be disposed of as per the merits, my lord.
Finally, this matter on 8th of April, by the time
Please.
the wakalat
My
shall
lord,
be filed.
date, my lord, date.
8th April.
8th is.
Please.
And by the time wakalat shall be filed by the respondent, by Mr. Venkatesh, and the papers shall also be served to the council within a week from today.
Please.
Hearing on interlocutor application, cell number 16, Mushtaq Ahmad. For appellant,
Yes, who appeals for the United India
United
Insurance? Who? You appear for United India? Mr. M. Venkatesh shall take notice on behalf of the respondent number 2, and the learned counsel for the appellant shall serve the copy of the appeal memo on the learned counsel. This is matter on 15th of April.
8th April.
Huh?
8th April.
8th April. Huh? No, that day will. Yes, 17.
cell number 17, Kamala DK.
I appear for second respondent, my lord. I pray.
Find objection.
Counter has been sent and I have to receive them, my lord, from the insurance company. A week's time may kindly be granted, my lord. There is a delay of 2,754 days delay.
When was the wakalat filed by you?
Well, wakalat is filed. Papers were not, it was filed in 2019, my lord. 11/11/2019. Papers were not available.
But we cannot keep on granting time. 2017, 2025 for counter, for objections.
My lord, it was, my lord, the Hassan, the DD was in 2010. Copy was not served and we have got the papers, my lord. I sent the counter also to the company for signature. A week's time.
Let's this matter on 19th of March. By
Please.
the time if the objections are not filed, basing on the material available, the IA 1 of 2017 will be considered. Yes, next.
For admission, cell number 18, Mushtaq Ahmad. For appellant,
Appearing for the.
2012 MFA.
Please, claim petition has been dismissed.
For representation, let's this matter for dismissal tomorrow.
cell number 19,
Yes.
My lords,
Shankaj K.
I'm appearing for the Shantaj K, my lords. My lords, there is no insurance policy, my lords. For the reason that, my lords, the check which has issued, my lords, in respect of the insurance amount, my lords, there has been dishonored, my lords. So there is no policy existed at the time of the accident, my lords. This is a claimant appeal, my lords, for seeking for enhancement, my lords. My lords, now the owner will be liable for the payment of the thing, my lords. My lords, I'm seeking for the enhancement, my lords.
Who appears to the owner? Owner is.
Served unrepresented. Before MSCT, yes.
Yes. So no, as far as that liability issue is concerned, you're not agitating.
No, my lords.
So then what was the amount granted?
My lords, 1,67,229.
How much?
1,67,229. Out of that amount, 20% contributory negligence has been fixed against the injured man.
It's a case of injury.
Injury, my lords. My lord, internal page 12, my lord, there is a quantification made. All aids have been. Is a pedestrian, my lord, 20% contributory has been fixed.
What are the injuries he has sustained?
He has sustained clavicle fracture, my lord.
Loss of memory, No, let's, in the discussion we'll see.
Para 15. They put us the medical bills of 26,416.
1 minute. Para 15.
Para 15 million medical regarding medical expenses and which was incurred.
Pain and suffering.
Please, my lords.
Fracture of right tibia and fibula.
Please.
Fracture of right ankle. So how many fractures?
Total 3 million.
How much is granted?
40,000 dollars.
Pain and suffering. For each fracture, it is 40,000.
No, million. 40 plus 10.
40
Plus 40,000 for one fracture plus 10 plus 10. 60,000 million. Lordship would have.
No, no.
Please.
There are 3 fractures.
Please, Milord.
So
For
each-
major fracture, Milord, 40,000 would be
40,000.
pain and suffering.
Ah.
Additional 10,000 for another fracture.
So like there are additional 2.
Two fractures.
So 60,000.
60,000.
Then what is his income?
They have claimed Milord 8,000 Milord.
He claimed 8,000.
8,000.
Court had taken
Supervisor.
how much?
Supervisor, he was doing.
Court had taken how much?
Please, Milord. 150 per day, Milord.
150 per day means 4,500 court
4,500.
had taken.
Please.
Which year is the accident?
2011.
2000?
11. 4/4/2011.
11 is 6,500.
6,000.
Loss of income. That is 6,500 into 3. Loss of income. $19,500. How many days he was in hospital?
Lords, 10 to 15 days they have stated, my lord. The court has coming to the conclusion, he requires for 10 to 15 days. Para 18 of the judgment. 8% disability has been considered. 18 is the multiplier.
20,000 we will take towards attendant, conveyance, food and nourishment. Loss of income during the later period it has granted.
5,000, my lords.
Loss of income during treatment, 1,33,632.
During
Look
later
at
period.
parity. It is loss of future income probably.
Loss of future income, my lord, 77,760.
No, income is 43,554. I think I'm looking at a wrong bundle. 794.
MEC number?
MBC 1797.
My lord, MEC number 7064 of 11. MEC 7064 of 11.
No. MFA 794
Of 14.
Yes, my lord.
of 14, but MVC is 1797.
7064.
Show it to him. According to you, what is the salary?
My lords, according to me, my lords, 8,000, my lords.
Something is wrong.
Here, my lord. I've taken a printout from the website. Something is missing, my lord. MEC number itself is wrongly. Party name is different. Party name is also different. And like Monday, my lord, I will clarify.
This is marked up on Monday.
Because here, my lord, the liability is fixed against us only, but in the judgment which has been downloaded, check bones case issued, the liability fixed against owner
I
of the
think
vehicle.
both of you have taken a wrong MVC.
Please.
That is the MVC.
Sorry, my lord, sorry.
This matter on Monday at the request of land counsel for the petitioner. Appellant. Next one.
Please, my lord.
Cell number 20.
I am for respondent number 4 in this case, my lords.
Where is the counsel for the appellant? No,
Text read.
no representation for dismissal tomorrow. Yes, 21.
Cell number 21. Oh, Mahesh.
I'm appearing for the respondent in this, my lord, sir. This is a case where there was an accident between auto rickshaw and bike, and 3 cases were connected, my lords. 7
One more is not listed.
Huh?
One more case is not listed.
No, all of them are listed. The major case in which there was a grievous injury, the Honorable Court has passed an order and enhanced the compensation and dismissed the application also. These 2 cases, my lords, MEC 798 and MEC 800, which is listed here today as MFA 2799 and 2800, they are of the same accident but of minor injury, which is daughter and wife. The appeal may be dismissed and the order of the tribunal amount deposited by the trial court may be upheld, my lords. The lower court had awarded a compensation amount of rupees 10,000 and 7,500 at 6% interest per annum. The first copy is
Yes, Mr. Mahesh, are you on liability or on the quantum?
My lord, serial number, my lord?
Serial number 21.
Yeah, 21, my lord. This is regarding the, my lord, the liability. It has been held, my lord, the petitioner himself was the, my lord, responsible for the accident.
The connected appeal, the court has enhanced the compensation and allowed the appeal.
I'll check up, my lord. I'll check up. And let them give the number, my lord. I'll check up.
MFA number 2799 of 2015.
2799 of?
2799.
It's mentioned in the list.
That is 28.
Well, it's MFA 2.
800.
MFA?
My lords, the
Connected matter is there, sir.
That is 2798 of 2015.
Yes, ma'am. Yes,
and 8205 of 2014.
yes, ma'am.
Please, I'll check up, my lord.
Well, not, it's actually the incident is of the year 2012, and the amount which they have deposited already will go back to the auditor, and then it becomes very difficult for them to retrieve because these 3 cases were connected. The lower court records have been come here.
We'll have it on Tuesday.
Oh,
This is on Tuesday.
much obliged.
Cell number 22. Pawan Chandra Shetty. For appellant.
Then for the appellant, my lord.
Yes.
My lord, liability fixed against the owner of the vehicle. My lord.
Both of you are ready?
Lordship, I am here.
Take it up in the afternoon.
In my vehicle, there is no policy.
No, Mr. Ravi Shankar.
Yes, your lordship.
We'll take these matters in the afternoon. So that we'll complete the list.
Yes, your lordship.
Afternoon pass.
Fine.
Much
Much obliged.
Yes,
Cell number
23.
23.
For respondent number 1 in this case, my lord.
My lord, I am for appellant. My lord, matter may kindly be admitted and it may be posted for final hearing. Case of dismissal, my lord.
Admit, post for final hearing. Yes, next. 24.
Cell number 24. Cell number 24. A.N. Krishnaswamy.
Yes, admit, post for final hearing.
Cell number 25. Consider R.
This matter, my lord, is you have both the insurance company and myself has agreed for 1,50,000.
Huh?
We are agreed for 1,50,000 global compensation, my lord. This is a workman's compensation case. My lord,
Can it be referred to the Lok Adalat?
maybe it may be disposed of today, my lord.
Pass over, ask
Please,
him to come.
please.
Pass over.
Yes. Cell number 26.
Appearing for the appellant in this
Ramesh
matter,
K.
claim petition was dismissed.
Okay, for respondent number 2, Miller.
Yes, Sarmati for. Yes. Both of you.
Your
are
Lordship,
ready, we'll
the
take it
claim
after.
petition has, Your Lordship,
Take it
claim
in
petition has been dismissed. Please, Miller.
Yes, afternoon. Yes, next.
Cell number 27. Ashok N. Patil.
Appealing for appellant, my lords, and then objection is ready, my lords. I will file it in the counter, my lord.
Of that amount, my lord. For that, they have to file objection.
For release of amount.
For release of.
They have challenged the liability, my lord.
Then in that case, how can we permit you to withdraw the amount? We'll hear the matter itself.
My lord.
Both
Yes.
of you are ready?
I'm
I
ready,
file the objection, my lords, in the court.
Forget about that objection. Are you ready with the main matter?
My lords, kindly it on next week, my lords.
Wednesday, we'll have it.
Please.
We'll dispose it of.
Please.
This is matter on Wednesday.
12-3.
At the request of the council.
My lord, in the second matter, no notices are served, my lord. In the second petition, my lord.
1 minute.
That is connected.
27.1.
Please.
In 27.1.
They have not taken steps since 2018, my lord.
My lords, a week's time.
No,
I'm
I
the
cannot take-
appellant in them.
Same parties,
Same.
but the respondent also same respondents.
no, different
res-
respondent.
Different.
Then we will deal this case independently and in that we'll order the
Please,
notice.
please.
Non-compliance of office objections on return of, has to furnish 2 sets of appeal copies. In
I'll
2018
furnish.
appeal. In 2018 appeal,
Also,
till now, you have not complied with the office objection.
my lords, earlier it was handled by some other advocate, my lords. Subsequently, it was allotted to me. My lords. I have asked for the appeal memo, my lords. I will furnish the copies.
R1 and R2, 2 sets are not a division bench. Office objections shall be complied with within a week from today, or else the appeal shall stand dismissed without further reference to the court.
Please.
Serial number 28. Sharat S. Gowda.
For
This case, I think it's a part-heard matter.
We'll have it in the afternoon, this list. We'll have it because all these matters.
Any other
finally-
day, my lord? Any other day?
My lords, it's
I
almost
had
third
some other inconvenience.
Monday.
Tomorrow,
Please, ma'am.
tomorrow also inconvenient.
No, my lord. Any-
Please, my lords.
Because what happens is now, if now some of the matters, if have to be finally heard in that caption, the entire list.
Please, ma'am,
again,
please, ma'am,
people-
please,
The
ma'am, please.
advocates will be waiting.
Please, no,
So all
But-
hearing matters will take it up.
we will.
My lords,
Yes,
the-
next.
Pertaining to this matter, my lords, pay and recovery.
That's what, we'll
Please,
pass orders
Please, ma'am.
tomorrow morning.
Please, my lords.
Yes.
Order serial number 1, list number 2. List number 2, serial number 1, Prasad B.S. for petitioner.
No representation for the petitioner. This is matter for dismissal tomorrow.
Serial number 2.
I am for the
Guru
petition, my
Datta
lord.
K.
I am for the petition, my lord. This is the wife petition, the transfer petition from Kundapur to Bangalore, my lord. The respondent herein is filed a conjugal right in MC number 13 of 22 that is pending before the Honorable Senior Civil Judge Kundapur, my lord. And the petitioner
One
hearing,
minute, 1 minute.
please, no.
Transfer petition is filed by wife or husband.
A wife, my lord.
Wife filed the transfer petition.
Please, no.
Husband has filed the MC for divorce.
Not, it is a restitution of conjugal right.
Husband has filed for restitution.
Please, no.
Where he filed?
In Kundapur, my lord.
Where is the wife residing?
A wife residing is in Bangalore.
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 When is the MC filed?
The MC filed
Why there is no
2000.
video?
22, my lord.
Sir,
22.
you on your video, sir.
Video on.
Your,
Sorry. Ma'am. Okay. Please.
Yes.
MC 13 of 22, my lord.
What is the stage? What is the stage of
This is
the
for evidence to you.
trial has commenced?
Not it.
No, evidence has started. If it is posted for evidence, the trial has commenced.
Posted for evidence.
Any stay in this?
Please.
Stay.
Stay is the interim order. After it
When was it granted?
was granted on 1/9/2023. Ma'am. They granted the issue emergent 1/9/23. One more case against the respondent, 498A is there, Bangalore. And he is a software
No
engineer.
interim order granted in this.
No, madam, 1/9/2023. Interim order is there. First September 23.
Stay of further proceeding in MC number 13 of 22. Senior Civil Judge Kundapur.
Why was it adjourned on so many occasions? Why it
please,
was
ma'am.
adjourned on so many occasions?
So because we have took this one time, both the parties took time because of settlement. They have this one. They have seen some some avenues for settlement, my lord, but it was not happened.
Sri Gurudatta K and counsel for the petition appears through video conference and seeks time to file relevant documents. What are the relevant documents?
No relevant record with regarding to the case filed by the respondent against the petitioner here and his parents, my lord. That criminal case is pending in Kundapur, my lord. That we have not this one, and it is a subsequent to the filing of this case, my lord.
No, husband had filed the MC for restitution.
Please, ma'am.
Wife has filed any cases in
The
Bangalore?
criminal miscellaneous for maintenance
When was it filed?
in Bangalore in the year 2022, my lord. Same year. On 21/1/22, my lord.
Heard the learned counsel for the petitioner in part. No representation for the respondent. List this matter as part heard tomorrow.
Till number 3. Till number 3. Vamshi Krishna.
Needful done, ma'am. The amendment application has been filed, my lord.
Of the parties, non-filing of necessary application regarding the address particular of respondent by advocate for petitioner. What happened? What is this?
Some typographical errors are there, my lord. That same has been filed through amendment application, my lord, for rectifying the address.
What is the CP?
It is a transfer petition, ma'am.
Filed by?
Filed by the wife, my, that is, husband has filed the petition before the Honorable Family Court in Bangalore, my lord. And whereas before that, prior to this itself, the wife had filed a petition before the Bangalore Court, Family Court, my lord. That is.
So from 2023 till now, notice is not sent.
Notice is not been served, my lord.
Served is you have to do the all.
We had furnished the proper, but in the cost title it is appeared wrong, my lord.
The petitioner delete from the caption for dismissal. Then counsel for the petition shall take out the hand summons on the counsel appearing for the respondent before
Please,
the trial court and shall file a memo to that effect by 19th of March, or else the stay granted by this court stands vacated without further reference to the court.
Till number 4. RB Deshpande.
Delete from caption dismissal.
Needful done, my lord. We already paid the process, my lord.
Awaiting service of notice. The learned counsel submits that they have already paid the process. In addition to that, learned counsel for the petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 19th, or else the stay granted by this court shall stand vacated without further reference to the court.
Till number 5. Nataraj Baba K for orders.
My lord, for
Okay,
petitioner,
what
in this transfer petition, respondent is purposefully not taking the
You
summons. So
serve notice
we
on
will
the
make
counsel.
once again the process.
Serve the counsel appearing before the trial court, same hand summons on the counsel appearing for the respondent before the trial court and shall be filed by 19th. Stay is there in this.
Stay is fine.
Stay will be vacated if it is not, the memo is not filed by 19th. Yes, next.
Till number 6. Puneet C. Or 1 to R10. Address in not in stay.
Well, in respect of R379
Then what transfer you are seeking?
well, transfer of a suit, there are two suits being filed, my lord. My lord, may I explain for a moment, please, my lord? My lord, respondent number 12 and the first petitioner, my lord, they are sister-in-law. That is to say, my lord, first petitioner husband and respondent number 12, my lord, they are brothers and sisters. My lord, what happens, please, my lord, respondent number 12, she executes a registered release date in respect of the suit properties in the year 2019, relinquishing her share. My lord, in the year 2022, please, my lord, first petitioner husband died due to liver jaundice. Thereafter, please, my lord, within 3 months from the date of death, respondent number 12, she files a civil suit, please, my lord, before the civil court. My lord, thereafter, please, my lord, the mother-in-law of the respondent number 12, that is to say, my lord, respondent number 2 herein, my lord, she files a civil suit in respect of the very same properties before Kunigal. Now, please, my lord, I'm seeking a transfer of suit. That is to say, my lord, the suit filed by the respondent number 12 in the Bangalore to Kunigal. Why? Because, please, my lord, there are two civil, there is already a civil suit filed in OS 325 of 2023, filed by the respondent number 2, who is none other than the mother-in-law of the respondent number 12. They choose to file a suit in two different places, though they are residing in the very same roof.
Which year are these suits?
My lord, suits of the year 2022 and 2023. Now there are two criminal cases also being lodged against me, which are being pending before the Kunigal court. Now, my lord, I am the petitioner, my lord. She has one daughter, my lord. She is, my lord, since she is 6 years old.
Which respondents are to be served?
My lord, respondent number
7 to 10.
37.
Respondent?
7 to 10, 3. 3 and 7 to 10.
3 to 7 and 9 to 11.
To R7, it appears.
Yes. The contesting, my lord, they are being served.
Then you file a memo.
The plaintiffs in both the suits, they have been served. In trial court, please, my lord, the matter is set down for cross-examination. My lord, I'm only seeking for stay of that, my lord, for the limited purpose.
It can't be.
Why? Because, my lord, two different suits, my lord, in respect of the very same suit.
Doing till the matter is set up for trial.
My lord, that in the year 2023, please, my lord, I was served with the notice of the subsequent suit.
Should have sought for it by that time.
Allah, I've been served with notice very recently in OS 3.
It is.
Please, my lord.
How recently it was?
My lord, I have to say prior to the filing, my lord, not less than 5 to 6 months, please, my lord.
5 to 6 months is not recent. We will not stall any of the proceedings. Now, if according to you, so-and-so is not a proper, the notice can be dispensed with, then you file your memo to that.
My lord, I've been told that they have been not served before the trial court also. If that would be the case, my lord, I'll file a memo to that extent. I'll verify that particular aspect, and if they are not being served, my lord,
if they are represented by the advocates before the trial court.
Since they have not been served, my lord, they're
whatever it is, you come up with an application, we'll look at it and then pass orders. No stay now.
My lord, since if the cross-examination is being commenced, only for the limited purpose. Why? Because please kindly peruse the schedule in.
But you were aware of these proceedings 6 months back.
My lord,
you can take any steps. Why should the court stall the proceedings now?
My lord, the thing, my lord, what I would like to submit is that, my lord.
I understood you may have a case on the merits of it. For granting stay, no. When do you want?
My lord, apart from the, my lord, the financial status of the petitioners will also be taken into consideration, my lord.
That's not the concern of the court. So, when do you want?
My lord, may I request for, my lord, within 2 weeks, my lord, I'll secure the order sheet before the trial court in Kunigal.
This is matter on 20th?
20th would be.
Yes, at the request of counsel petitioner. This is matter on 20th. Yes, next.
Till number
Please.
7.
My lord, in the meantime, may I request
Venkatesh.
my lord, the postal covers and the sharas are not being placed. My lord, let the office, my lord, trace out the online copy and let them, that direction, my lord.
The registry shall pay for the court. All the postal share pertaining to the notice that is.
Online postal track sheet.
If it is there, it's fine. Yes, next.
Please.
Next.
Till number 7.
I appear for the
Chen.
petitioner, my lord. Lord, I have sought for transfer of the present suit before any other civil court, my lord, in the city, Bangalore city. My lord,
You are seeking transfer from?
From CH-40, Bangalore, to any other district judge, my lord, additional city civil judge, Bangalore. For this reason, Lord, I have got a permanent injunction of the year 2018 to 2022, 4508 of against the vendors of the present respondent, Lord. There was an injunction, permanent injunction order granted in my favor. Lord, after the grant of injunction, he also prefers an appeal. Appeal also came to be dismissed by this honorable court, filed by the respondent's vendor. Immediately, the respondent files an injunction suit against me and obtains an ex parte order of a temporary injunction. against the same subject matter which was decreed in my favor. Now, my lord, the ex parte injunction without notice has been granted by the court on 12/3/2024 in OS number 1777 of 2024. My lord, I moved the trial court, my lord, on 29/7 by filing written statement in 2 sets and also objections to IA. And the matter has been postponed by extending interim order. And my client has lost hope that he will get justice, speedy justice at the hands of the court. Therefore, the matter should be transferred to some other judge so that, and though learned judge at page 23, my lord, directs me to file an application for vacating injunction. That is also filed. Neither IA1 is heard nor IA number 3 is decided by the court. It is being dragged on and extension of temporary injunction is granted. Therefore, my client feels that he will not get speedy justice at the hands of the court. Therefore, the transfer should be made to some other judge, my lord.
What is the guarantee that the other judge will also, as per your client's expectation, will hear the matter?
But all judges are
that
alike.
is unfair.
But
Can't
this is,
transfer such a-
look at the order sheet, my lord. Look at the order sheet.
You have a remedy. You have a remedy, not the transfer. You can come up with before this court by filing a petition under 227, bringing it to the notice of the court that the learned judge is not taking up the matter, and this is how it is.
But
going.
order 39 rule 3A says contemplate that within 1 month.
I'm saying if that is he has not done, you have a remedy of filing a
But
petition.
that itself goes to show that the learned judge is lethargic and she is not caring for our applications. But she's simply extending up to 3 o'clock. We will sit there. After 3 o'clock, she will adjourn. This is the that's why I am come up before the court asking the court to direct any other judge should try the matter, my lord. We have lost hope because 12/9, my lord. 29/7 in the, your honor may kindly see the order sheet, my lord. Though I have got an injunction, permanent injunction decree, ex parte injunction is continued against me. I have obtained plan. I cannot proceed with the construction. The vendor's permanent injunction granted against his vendor. He steps into the shoes of his vendor and he is also bound by the decree. That is also brought to the notice of the court, learned judge. But this is violation of the order of Supreme Court as well as CPC, plain CPC, order 39 rule 3A. And she is not bothered to hear IA number 1 or IA number 3 filed by.
Please come. The present transfer petition is filed.
But I got a judgment of High Court, my lord. Where in similar matter, my lord, the court has granted in Guntur, 2 suits were filed in the same jurisdiction. And in Guntur, the learned High Court has transferred the matter, my lord, in the very same.
The present petition is filed. Draw. OS number. Yes.
Para 9 starts, my lord.
On what, for what purpose you're relying on this judgment?
This is regarding maintainability.
They're not on that. They're hearing the main petition, sir.
The office objection has to be overcome.
That I know.
Where?
The
Otherwise, your honor may kindly direct the very same judge to dispose of IS within a period of 30 days, my lord, in view of order 39 rule.
the present petition is filed, seeking to withdraw OS number 1777 of 2024 on the file of the additional judge, City Civil and Session Judge, Bangalore, and transfer the said to some other court in City Civil Court Complex, Bangalore, for proper disposal in accordance with law. It is stated that the petitioner had filed it is stated that the respondent herein had filed OS number 1777 of 2024 on the file of the What is this number? of-
39th additional city civil judge.
40?
39th additional city civil.
The additional civil
City
and
civil
session
judge,
judge,
CH-40.
Bangalore, for a bare injunction. The court had granted a temporary injunction as prayed for by order dated 12/3/2024. Thereafter, the petitioner herein has filed his wakalat on 29/7/2024 and filed written statement as well as objections to I number one, I number one. Even objections to the application on order 39, rule 1 and 2 were filed. It is stated that after the objections are filed to IA number 1, the matter is adjourned on 5/8, 13/9, 16/10, 2024, 29/10, 2024, 6/11/2024, 15/11/2024, 26/11/2024, 9/12, 2024, 17/12, 2024, and 7/1, 2025. It is the case of the petitioner that in respect of the very same property at 5 OS number 4508 of 2018 against the vendors of the respondents herein. And the said suit came to be decreed, and that was upheld by this court in RFA number 868 of 2022, disposed on 29/3/2024. In spite of the same, the learned judge is directing the petitioner, the petitioner who is a defendant in the suit, to file an application under order 39 rule 4 CPC, which was also came to be filed on 29/10/2024. It stated that the client and counsel appearing for the petitioner submits that the client has lost hope, has lost hope that he would get justice in the hands of the said court, and as such, they're seeking for transfer. It is submitted that the action, the not taking of this matter and adjourning it from the last couple of months is contrary to the provisions of the CPC as well as contrary to law. It is submitted that the matter may be transferred to some other court in Bangalore next para. This court, having heard the learned counsel of the petitioner, had produced the material on record. The contention that as the judge has not heard the matter immediately after filing their application, and the matter is being adjourned from time to time. And in respect to the very same property, the suit that's filed for injunction against the vendors of the defendant is already decreed and confirmed with an appeal. And as the judge is not taking, they've lost hope on the judge, and they want the matter to be transferred to some other court. Without going into the merits of the matter of the legality or the orders that are passed in favor of the petitioner and against the petitioner, that is an injunction that is granted. On these grounds, the cases cannot be transferred from one court to the other court. If the court is not disposing of the applications and keeping the matters pending, the petitioner is not remediless. He can as well come before this court by filing a petition, filing a writ petition under 227 and bring to the notice of the High Court how the matters are being dealt with by the learned judge and what is the injustice that is caused to the petitioner. But the petitioner has not chosen to come before this court under 227 by filing such an application. And if on these grounds, for taking up a matter the delays that are caused, and the pendency, and there are several other factors. On those grounds, the courts cannot, the High Court cannot transfer the cases from one court to the other court. In these facts and the circumstances, in the considered opinion of this court, on these kind of grounds, the court cannot transfer the matter from one court to the other court. Accordingly, this court finds no reasons to allow to consider, to entertain this application. However, considering the particular facts of the case, the learned judge, the so-and-so, what is that?
39th edition.
39th additional city civil and session judge is directed, the so-and-so shall dispose of the IA as expeditiously as possible.
Much okay.
Bill number
Accordingly
8,
disposed of.
bill number 8,
And with regard to the maintainability,
I number 1 and 2, my lord.
I number 1 and 2, with regard to the maintainability, the office objections are overruled.
bill number 8,
Here for the defendant. An application seeking relaxation of the video conferencing rules filed by the plaintiff. The plaintiff resides in the US, and therefore they want to not bypass the procedure of having a coordinator. There are three.
No. Why this matter is adjourned is to, when will, like, to tell a particular date, when you will complete his evidence if he comes to India.
So she has to let us know when she's coming. We will not take more than 2 days, in the span of 3 days.
That's how it is adjourned to today.
Yes.
Very easy.
Devraj
I
KS,
said, I'll not pass, because, first of all, the video conferencing for this cross-examination is, there has to be some rules into that effect. And now without, contrary to the rules and giving an exemption will not arise.
Yes.
So I told him, come to India, tell a particular date, ask for a date, and I'll direct that, and on those particular days, we should complete the process.
They may request the matter be taken up on Monday, so I will.
Yes.
But he's
I'm sorry,
on.
my lord. I'm
Yes,
sorry.
Mr. What's the date?
For the.
What is the date when he'll come down?
My lord, may I make a request? I will come at 2:30. I will just put forth my arguments today itself at 2:30. May I be permitted to make my submissions at 2:30. After that, I am at my lord's hands. May I come at 2:30 and matter
No,
may
I
be
think
passed-
that's what the matter is adjourned to today.
My lord, that's what.
Matter is adjourned to today to find
Yes.
out a date from their side when they will complete the cross-examination. What
Lord,
else you want to submit?
All I want to make my submission is, my lord, that I have already filed about 3 or 4 litigation, all of which are in the stage of evidence, my lord. Now, me being required to come down on numerous occasions.
You
it
would
will-
institute 101 cases and you'll stay out of country and you expect the court to have a.
My lord, may I make, my lord,
That's not possible.
I'm suffering a bit of a handicap. May
We'll
I
have
come
it on
there at
Monday, not
2:30,
today.
my lord?
Monday.
My lord, may I
Monday.
request, I'll come at 2:30 and I'll convince my lord on that. And
Monday,
thereafter, I'm at my lord's hands.
Monday.
It's covered by a lordship's judgment.
Monday.
Identical matter.
Monday.
My lord,
Yes.
today, may I request a short accommodation? Today, I'll just convince my lord on this. Otherwise,
But Monday, I have some inconvenience in the afternoon.
okay, my lord. Monday, I'll request my lord. I will.
Yes,
I'm-
next.
application, sale number 9,
For the appellant,
Mahesha.
second appeal of the land losers.
What is this recalling the order date?
That's what had happened. There were 15 petitions by the land losers.
Huh.
This petition was dismissed for non-compliance of the office objections, my lords. And similar matter have been disposed of, my lord.
This for non-compliance of office objection, my lord. More than
I
3.
said to you, you shall comply.
Let's no, my lords, since they did not appear today, yesterday it was posted for today, my lords. Lordships may give me 1 week's time, my lords, I'll comply, my lords, pending consideration of the IAs.
The pending consideration of I number 1 of 24 petition is permitted to comply with the office objections.
I had also paid
Or
the
its I number 1 of 24 shall stand dismissed.
MA was paid, ma'am.
Uh-huh.
In behalf of respond number 3 and 4. No, memo for appearance was filed yesterday. On
Yes,
behalf
ma'am.
of 3 and 4.
That note.
You know, this is listed after it.
Please.
Yes, next.
Sale number 10,
appear for the
Rachita Rashekar.
Yes. Senior counsel, my lords, is held up due to a personal inconvenience. It may be taken up in the afternoon session, my lords.
I told my learned friend afternoon, kindly excuse me, my lords, any other day, my lords. What to pass?
Monday,
My lords, tomorrow,
Please.
my lords, if possible. Tomorrow, my lords.
It'll be Monday or Tuesday tomorrow.
tomorrow, so you have no.
I pray for Monday or Tuesday, whichever convenient to my lord.
Monday.
Holy weekend is coming up, my lords.
Huh?
Holy vacations are coming up there for tomorrow, my lords.
Holy Bangalore.
Monday.
Please.
This is matter on Monday. Yes, next.
Great.
For 11.
Yes,
Bimbadar. SV Bhosle.
no representation on behalf of both the parties. This is matter for dismissal tomorrow.
Cell number 12 adjourned. Cell number 13.
Same order in this also.
Cell number 14 adjourned. Cell number 15. Kashyap and Nayak for petitioners.
Here for petitioner.
Mr. Rajendra Reddy.
Seeking a transfer of petition from the court of Davangere to Modugiri Civil Judge Court, my lord, on the ground of health. Modugiri Civil Judge Court, Modugiri, my lord. On the ground of the health of the petitioner, my lord.
Before this court is,
My lord,
petitioner before this court is,
the wife, my lord. It's a matrimonial dispute, my lord.
MC is filed when,
The husband in Davangere.
when.
My lord, MC is filed in 2024, my lord. It is still at the stage of summons. my lord.
24 seeking divorce.
Yes, my lord. Petition for divorce.
What is the distance between Davangere?
170 kilometers.
170.
170.
Any other matters pending?
No, my
Any
lord.
other matters pending
No,
at
my lord.
Madhugiri?
No, my lord. There is no matter pending.
Will transfer.
They are seeking transfer on the health issues, my lord. In fact, they.
From that also, even health grounds not there, then also courts are considering. Please. The present transfer petition, so petition is filed. Seeking to withdraw. Seeking to transfer MC number 168 of 2024. Pending on the file of the family court Davangere to the court of the senior civil judge and JMLC Madhugiri. The facts of the case are like this. The facts of the case are, there is petition herein. The marriage between the petitioner and the respondent solemnized on 7/5/2008. Any children?
Yes, my lord. There's a female child. It's
Age?
a 14 years as of now.
In the bedlock, they're blessed with a daughter who is aged 15 years. In view of the disputes between the parties, the respondent herein had filed MC number 168 of 2024 before the family court at Davangere. It is stated that in view of the disputes between the parties, the petitioner is staying along with her parents and she has to take care of the daughter, and also she's suffering with health ailments. In view of the same, the distance between both the places is about 170 kilometers, and it's difficult for her to travel all the way from what is this?
Badavanahalli, my lord. Her native is Badavanahalli. From that place to Davangere, it's about 170.
What is that? Madhugiri.
Madhugiri.
Madhugiri to Davangere. And such, they sought for the transfer. And counsel appearing for the respondent submits that, though it is stated that they're suffering with health grounds, no reasons are stated. If the matter is transferred as well, it would cause hardship to the husband. Next, for having got the counsels on either side, there is a material on record. The distance between Davangere and Madhugiri is about 170 kilometers. In the wedlock, they're blessed with a daughter who is 14 years old and residing with the mother. And the mother has to take care of the daughter, considering the inconvenience caused to the mother. This court deems it appropriate to allow this petition. Accordingly, the following: so-and-so is withdrawn from so-and-so and transferred to so-and-so. the wife shall cooperate with the trial and shall not seek unnecessary adjournment. Next.
Till number 16.
Any specific date to be appeared for the parties to appear before the
Further notice from the court. Both the parties shall appear before the court on 7th April.
Please.
On 7th April.
Till number
much
16.
of
Chandrana HP for petitioner, Narayan Swamy.
They're seeking transfer of the OS suit from, it's a husband and wife case. I'm the wife.
When
filed.
counsel for the petitioner is present, no representation for the respondent. This matter is part for tomorrow.
Interim order.
Interim order earlier granted is extended to them. Next.
Till number 17. Mahabaleshwara, okay.
Second petition, I'm applying for petitioner. The second petition, I'm applying for petitioner. It's a wife's petition. First petition is filed by husband.
Husband and wife petition.
So who filed
First petition by the husband for divorce at Bangalore on 24 August 2024.
no. The first petition is filed by the
Husband.
What is the MC is filed by whom?
MC by the
Filed MC for divorce. Wife filed MC for restitution.
restitution.
Restitution where and MC where?
MC is in Bangalore, restitution is in Shumaga. It is
Shumaga.
Shumaga. It is more than 300 kilometers.
Not 300,
Bangalore.
280 kilometers.
Illa.
80 kilometers.
So from family court, it is around 316 kilometers. It is in Google Map, it is coming like 316 kilometers.
What the wife is doing at Shimoga? She's working.
She is with her parents. Their parents are
Before-
agriculturist.
Before the separation.
So
they
what
were
is
residing in
what has
Bangalore.
happened is after 6 months of marriage, she has been driven out to the parent home, stating that she has to learn some cooking. She doesn't know the cooking, so she was sent to come by learning cooking and to come back. In the meanwhile, after 1 year of after 4 days of marriage, 1 year of marriage, MC petition has been filed. Immediately after 4 days of marriage, 1 year.
4 days of marriage.
One year.
Oh.
MC petition has been filed.
MC petition for?
Divorce.
Hmm.
Alleging some, making some allegation against a wife. So that petition has.
Yes, no, we are on the transfer petition. Yes, what is?
No, kindly take the objection filed in 409
Hmm.
or the petition 529. In the synopsis, now she is an engineering graduate at the time of marriage and subsequently she was working in Bangalore. And I have also produced the subsequent appointment letter also.
Where is that?
Is it page number 59, 47. It was that she was earlier working in 2018 and she was relieved on January 18, 2024.
So filed CP 409?
409 I have also filed objection.
Wife petition.
Yes.
409 is by the wife to transfer the case from.
Where are these objections?
In 409 I have filed, or if it is 509 also I have produced the medical documents of the parents of the husband and also the complaint lodged to the police.
Please show to the court that the lady is working in Bangalore.
No, annexure R5, page 47. It was earlierly she was working along with the objection.
Oh, she is not working. She has left job immediately after.
I will also take your lordship the medical
Got the appointment
medical
in,
document.
As per.
Earlier,
One minute,
Please,
both
please.
of you, let me first look
Please.
at what is page 45?
page 47, annexure R5, in my objection filed to the 409.
January 19, 2024.
Yes,
Hmm.
she left it. Second document R6, 6 May 2024 is the appointment letter. Pleased to appoint you as a business development manager. Anita Patel, it was 6.
What is the restitution file?
Restitution filed.
Restitution filed on 30th of September 2024.
So please show to the court.
Yes.
After 30th September 2024, she is residing in Bangalore.
No, but I am told by the husband that she is a engineering.
File an
graduate.
affidavit before the court
Please, please.
stating that you are not working in
Please.
Bangalore
Please,
and you are residing in Shimoga.
please.
No, one more thing apart from that one. Kindly see page number 26 in the objection. Before that one, page number 25.
Yes.
These are all the two complaints were lodged. Page number 19, your honor may kindly relax. Page number 19, 2/6/2024.
Even till 15/9/2024 also.
Yes,
you are
police
residing
complaint.
in Bangalore.
Yes.
Then why did you file a restitution petition in Shimoga?
No, like what happened? She come to join the petitioner, but she was not allowed to enter the house. That's the reason she has filed a complaint.
No,
Ah.
your complaint is dated 15/9/2024.
Which document?
9 is September.
September.
And 30th September is your, yes, learn counsel for the petitioner, learn counsel for the wife, husband submits that. Learn counsel appearing for the husband submits that. Wife is residing in Bangalore. And in support of it, he has filed the complaint.
That is
given by-
complaint lodged by us.
Huh?
That complaint is lodged by the father of the husband.
The appointment letter, and he submits that she's staying in Bangalore. But the case that she has instituted the MC in Shimoga only to cause harassment to the husband. Then counsel appearing for the wife has denied the same. The wife shall file an affidavit before this court stating she shall file a clear affidavit whether she is working, if she is working, where she is working, and presently where she is residing.
Even in the cost
the
title
next-
filed by the MC
By the,
petition.
by the
by
next,
them.
and when, till what time she was working in Bangalore, when she went to Shimoga, Shimoga, and whether she's working at present or not, what has happened to the earlier job.
Even in the cost title, in the MC petition
Please let
filed
her
by
come
them,
up with an
they have
affidavit.
mentioned, they have mentioned the address of
Then
Shimoga.
there will be some accountability will be there.
Please, please,
Tell your client,
please.
she will be doing it at her risk. Yes.
Interim order.
You have date could.
Interim order earlier granted is extended. List this matter on 1st of April.
You have date.
Yes, sir.
Till number 18,
For the petition,
Jagdish, KJ.
wife's petition.
Hmm.
Husband has
From where to where?
from Srinivaspur to Bangalore, my lord.
From?
Srinivaspur, my lord. About 120 kilometers from Bangalore, my lord.
Let me just see the name. Srinivaspura
Please, my lord.
to
Bangalore, my lord.
Bangalore.
Please. my lord.
Already the pendency in Bangalore is more. You will get speed
ma'am, she-
disposal if it is at that place.
No, my lord, she is residing here only, my lord. There is no
that's
direct
true.
bus also, my lord. That is the
Huh?
problem. She has to change 2 buses, my lord, to reach the Srinivaspur, my lord. And there are more.
What is the husband's MC? MC for?
For restitution of conjugal rights, my lord.
She wants to go or do not want to go?
No, she wants to go, my lord. Earlier, actually, both of them residing in Bangalore only, my lord. It is Srinivaspur, Gaunipalli is a Mufsel village, my lord. Where, my lord, there is no earnings also there. That's why, my lord,
No, happily, if the matter is at Kolar or at Srinivaspura,
Srinivaspur.
it will be disposed of because there is less pendency there. It will take 4 years more than there.
No, here there are 6 to 7 courts, my lord, in Bangalore.
7 courts are there. As well, the pendency is 7 times more than what is there in Kolar.
No, my lord, here it's.
No, we know that. What is the pendency and how much time it is taking.
Please, my lord.
And even 17, 18 matters are not disposed of till now in Bangalore courts.
The speedily
In
disposal.
other courts, it is 2021 is going on.
No, actually, my lord, in Srinivaspur also there is no regular court, my lord. Only weekly, once the court has been sitting there.
Is
Judge
the
was-
present petition is filed seeking transfer of MC number 48 of 2023 pending on the file of the second edition senior judge and JMFC Kolar
No, Srinivasapura, my lord.
JMFC Srinivaspura to the Principal Judge Family Court at Bangalore. It is stated that the facts are the marriage has taken place on 21/2/2022. And in view of the differences between the parties, on 9/12/2023, the husband has filed the petition. That's MC number 48 of 2023 on the file of senior civil judge and CJM Srinivaspura seeking restitution of conjugal rights. On 18/10/2024, the petitioner had appeared and filed her objections. It is stated that she is staying in Bangalore and it is
20 kilometers, my lord.
120 kilometers from Bangalore, and it's very difficult for her to travel all the way from Srinivaspura to Bangalore. As such, she has come up before this court seeking transfer of the transfer of MC number 48 of 2023. Though notice is served on the respondent, there is no representation. No wakalat is filed on behalf of the respondents. Considering the next part, having heard the land counsel of the petitioner, there is a material on record. Considering the fact that the distance between Bangalore and Srinivaspura is about 130 kilometers, and considering the inconvenience to the wife, considering the inconvenience to the wife, this court is passing the following order. MC number 48 of 2023, pending on the file of the second additional senior civil judge, as Srinivaspura is withdrawn and transferred to the why to the principal judge family court. You come within the judge.
No, my lord, the judge has to allot the cases to other cases.
The principal judge family.
He is the
court at
administrative
Bangalore.
judge.
Yes.
They will allot it.
Bill number 19. Rakshit DJ for petitioner.
The present petition arising under an
I
execution
think it will
procedure.
take some time. We'll hear it after lunch. It's already 1:12. Yes, after lunch. Next.
20. Patel Sangangauda Gudangauda.
I pray for time to file objection in IA number 1. 1 week's time may be granted.
Non-filing of objections to IA 1 of 23 as per the order dated 5/12/2024.
And also they are not served copies, so.
I have for the claimant appellant, my lord, serial number 20, my lord.
How many days, how much time you will take for objections?
Lord, in copy is also not served by.
This is the appeal memo. Last time it has come up before me, if I'm
No,
right.
we have served, my lord. We have acknowledgement. We have served acknowledgement. Now today we have this one. Long back we have served.
Please, wait a second. 1 week's time may be granted. Finally.
Finally, a week's time. No
Please.
further adjournments. We'll
Please.
pass orders.
Please.
Finally, at the request of land counsel for the learned
Government. HCG.
government advocate,
CGP.
SCGP, this matter on 18th of March. No further time will be granted.
Bill number 21. 21 Sri Prasad Payas.
Filed out objections.
Hmm?
We have filed out objections yesterday. As I submitted in the last occasion, we're saying that we'll be filing objections. That has not been put up. Your lordship may fix a date, Miller, so that we can argue the main matter itself.
Any statement.
Any interim order is there in your.
Yes, yeah, it might be extended, madam.
This is matter at the request of the counsel for the respondent on, we'll have it on 25th.
25th. Yes, ma'am.
On 25th, interim order earlier granted is extended till then.
26th, madam.
26th better. Your lordship may have it on 28th otherwise, if they have any difficulty.
28th.
We'll have it on first April.
Achha.
Yes, next.
In passport matter, in serial number 1, madam.
Serial number 1.
The other side has raised the one objections. There is another matter in the pending before the Chitradurga courts.
In
That
which
suit
case?
is, that matter is for filed by the father-in-law of the petitioner. Yes, madam. My father-in-law of the petitioner in respect of the suit properties, madam. That property, that suit cannot be transferred into any Davangere court, madam. And
So the point is, you have to travel for that.
not, my lord, because the petitioner is residing in remote area, Malebennurs, which is situated in Harihara taluks. And she has to come to Harihara and then she has to come to
I
Davangere.
understand that, I understand
madam.
that.
Yes, madam.
No, as you say, as you
Please.
submit, the matter that is already, the suit that is pending cannot be transferred.
Yes, madam.
You have to appear there every time.
No, my lord, that suit is for only for bail injunction, my lord, not to enter into the matrimonial house filed by the father-in-law. That suit is not maintainable. I filed application also under Charter 7 Rule 11A of CPCs. And further, my lord, in the family court at Davangere, there are other two matters
No.
pending in family judge court
See, filed by the husband at which place?
in Chitradurga court, madam.
Chitradurga. Which year?
This petitioner is the respondent in the said
See, MC of
MC
which year?
6/24.
You are staying in?
I'm staying in Malebennuru, Harihara taluks. It is nearly far away from the 120 kilometers, madam.
Let's see, what is the name? I'm not able to.
Tejaswini.
Please.
Petitioner name is Tejaswini,
No.
Chitradurga courts.
Chitradurga transfer to Davangere.
Yes, ma'am.
Distance is?
And it is requested to transfer to the family judge court, Davangere, ma'am.
Distance,
Distance is about 120 kilometers.
120 kilometers.
Yes. And more so, my lord, the petitioner wife has filed 3 cases in the Davangere family judge courts. One for restoration of conjugal rights. Another suit is for not to marry another bride for the second marriage. And third is for maintenance on the earlier CRPC, 125 CRPC.
My lords, in addition to the OS, my lords, pending in Chitradurga, my lords, petitioner herself has filed a criminal case, my lords, against the respondent and his family. Still it is pending in the Chitradurga court only, my lords. For that also, she has to travel from the place of Malebennuru to Chitradurga.
But the prosecution, prosecution will take course of the
But she
investigation.
has
my
to
lord.
give the evidence.
Because
She is the victim there.
Because when I entered into the house of my husband
File seeking transfer.
on 18/3/24,
Number
the
6 of
husband has been
2024.
assaulted, my lord,
On the file of the second edition, senior civil judge and JMC.
and
court,
threatened
Chitradurga.
also to the life.
Transfer the same to the family court at Davangere. The facts of the case are the marriage has taken place on 24/11/2021 and no children.
No children.
And on 11/1/2024, in view of the differences between the parties, husband has filed MC number 6 of 2024. 24 seeking restitution of conjugal rights.
Yes, ma'am.
Or divorce.
Divorce, my lords.
He has filed the for
Filed by
divorce.
Second edition senior civil judge and JMFC, Chitradurga. The wife is residing at
Malebennurs, Harihara taluks.
where did you say the name of that place?
Lords, in the cost.
Malebennur, Harihara taluks. In the cost titles. At page number 3.
She is residing in
Malebennur, Harihara taluks.
Malebennur, Harihar Taluk, Davangere district, along with her parents. She has also filed MC for restitution of conjugal rights
In
Davangere.
in MC
in the
number 1.
family court Davangere, and also filed the petition of 125 CRPC seeking maintenance and
OS 27/24 restraining the second marriage.
also another suit is filed. The land council appearing for the petitioner submits that all as 3 matters are pending before the family court at not family court at Davangere.
And life
These
threat is given.
matters may be transferred, this matter may be transferred to the court, and it's very difficult for her to travel all the way 120 kilometers on each date of hearing. Next parallel counsel appearing for the respondent submits that the respondent husband submits that the wife had filed a criminal complaint against her husband that's pending on the file of that's pending before the courts at Chitradurga. The father-in-law had filed a case against her, a suit against her that is pending. And as such, even to attend those cases, she has to travel to Chitradurga. And there is no point in transferring these matters to Davangere. In response to that, land council appearing for the petitioner while submits that in a criminal case, the prosecution will take care only when necessary. She has to appear. Whereas the family matter, she has to pursue and she has to travel frequently.
And life threat is given, my lord. And life threat is given on the appearance day, my lord.
And it stated that there is a threat to her life. Next, for having heard the counsels on either side, produce some material on record. There are 3 cases pending at Davangere, 3 cases pending at Chitradurga. The distance between the places is about 120 kilometers. As rightly submitted by the land counsel appearing for the husband, the counsel appearing for the wife, for the criminal matters, at every time her presence is not required. And whenever it is, the prosecution will take care of the cases, and only when her presence is required, she can appear before the court. And then for the matrimonial matters, she has to travel 120 kilometers, and it would cause a lot of inconvenience to her as she is staying along with her parents. In that view of the matter, this court, in that view of the matter, this court is inclined to allow the petition and accordingly passing the following order. So and so is withdrawn from so and so and transferred to so and so.
Much obliged.
Will call one matter, one and not call.
List number 3, cell number 1. A. Krishnaswamy,
Yes.
for appellant, Pundi Kaishwarabat.
Where is the advocate for the respondent?
Respondent, I am appearing in the 10,954.
Indika Ishwarabat represents for respondent. He is not present.
That's what.
And he is appellant in the connected case.
Passover? Passover?
I leave it to the court.
We'll see. If it doesn't come, then we'll action. Yes.
Cell number 2. Cell number 2. Narendra Gowda, for appellant.
Passover 3.
Cell number 3. HR Renuka.
Passover.
Cell number 4, adjourned. Cell number 5. M. Anil Kumar.
Passover.
Cell number 6. Shashikant Prasad.
It's Passover.
Cell number 7. SG Egde.
Passover.
Cell number 8. Omayesh.
For the appellant.
Are you ready?
Yeah, I am ready.
Passover. Yes. 9.
Cell number 9. AM Krishnaswamy.
AM Venkatesh.
Venkatesh.
Why are
I
you
am
reading
for the
it as
respondents.
submitted? Both of you are ready?
Yes, ready, my lord.
Yes. Passover.
Please.
Cell number 10. Shanti Bhushan.
Raise a short accommodation.
I am a respondent.
AN.
This is matter on at the request of land counsel for the appellant. This is matter on 7th of April.
Number 11.
Passover.
Shetty.
Passover.
Cell number 12.
11th, my lord, I represent.
I appear for first respondent.
Passover, sir. Cell number 12. Satish B.
I appear. I appear.
12 adjourned. Cell number 13. Girish B. Baldare.
My lord, in this matter, I require some time, my lord.
Some
time may kindly be granted.
Respondent.
At the request of land counsel, the respondent, this is matter on 9th of April.
Sorry, my lord.
Cell number 14. Shashidhar R.
Passover.
Cell number 15. Sanjay Shavali Avaji.
Why? We'll hear it. Afternoon Passover. Yes, 16.
Cell number 16. Ashok N. Patil.
Passover.
Cell number 17.
Appellant, insurer appellant, liability, I am ready, please.
Pastor.
Afternoon.
Cell
Yes.
number 18.
Yes, 18.
18.
Sachin, yes.
Sachin PS for appellant.
Applicants not produce the translated copies.
Non-production
applicant.
of
Not produce the translate.
We'll
As-
see in the afternoon.
Please.
List 2 serial number 10, it is that.
Uh-huh.
List 2 serial number 10, it is urgent to Monday. One request, my lords, if it can be taken up on top of the list on Monday.
No special treatment for your client all the time. Why should be taken at,
No vacations as well.
let it be. Everybody has this, the same problems. No out of the way and the special
Training also, my lords.
special treatment for, special clients.
Order of restraining.
No, it will be. We will hear it in the usual course. No special,
ಹದಿಮೂರು ಅಲ್ಲ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನೋಡ್ಬೇಕು. ಉಮೇಶ್
ನಮ್ದು ಉಮೇಶ್
13 ಅರ್ಜೆಂಟ್
ಎಲ್ಲ third
13.
ಜಗದೀಶ್ ಅವ್ರ ನಿಮ್ಮನ್ ತಗೊಂಡಿಲ್ರಿ, ನೀವ್ ಹೇಳ್ಬೇಕು. ನಿಮ್ಮನ್ ಕೇಳ್ತಿದ್ರಲ್ರಿ ಜಗದೀಶ್, ನಿಮ್ಮನ್ ತಗೊಂಡಿಲ್ಲ, ನೀವ್ ತಗೊಂಡ್ರಿ ಅಂದ್ಕೊಂಡೆ.
serial number 13. Girish Paldare, yes, urgent to 9-4. 9-4 ಅಲ್ವಪ್ಪ ಅದು?
ಅಲ್ಲ ಲಿಸ್ಟ್ 2 ಮೇಡಮ್.
List 3-13. ನೋಡಲ್ಲಿ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2
11 ಇದೆಯಲ್ಲ?
13ನೇ ಮ್ಯಾಟ್ರು.
11.
11 13
ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 2 13ನೇ ಮ್ಯಾಟ್ರು.
ಎಲ್ಲಿ ಇರ್ತೀರಾ ಸರ್? ನಾವೆಲ್ಲ ಊಟ ಮಾಡಕ್ ಬಿಡಿ. ನಮ್ಮ
ಊಟ ಮಾಡ್ಕೊಂಡು
ಎಲ್ಲ ಹೋಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ, ಎಲ್ಲ ಆರ್ಡರ್.
ಅಲ್ಲ ಮೇಡಮ್ ಅದೇ ಚೆಕ್ ಮಾಡಕ್.
ಇದು ಡೇಟ್ ನೋಡ, ಇದು the request of land council for the respondent serial number 13 in list 3. 9-4 correct ಅಲ್ವಾ? ಅಲ್ಲ ಇವ್ರೆ, ನಿಮ್ಗೆ ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಕೇಸ್, ಅದಕ್ಕೆ ಪ್ರೆಸೆಂಟ್ ಇರ್ಬೇಕು.
ಮೇಡಮ್ ಆನ್ಲೈನ್ ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಬರ್ತಿಲ್ಲ ಮೇಡಮ್ ಅದು. ಒಂದೇ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ 2ನೇ ಇದೆ
ಅವ್ರಿಗೆಲ್ಲ ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಬರ್ದಲ್ಲೇ ಬಂದ
ಅಲ್ವಾ? ಅದು ನೋಡಿ ಮೇಡಮ್, ನಾವ್ ಅದಕ್ಕೇನೆ
ಏನಾಗಿದೆ ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ತೋರಿಸ್ತದೆ.
ಇಲ್ಲಿ ತೋರಿಸುತ್ತೆ, ಔಟ್ ಸೈಡ್ ಅಲ್ಲಿ
ಮಾಡ್ತಿಲ್ಲ ಮೇಡಮ್.
ನಾವೇನ್ ಮಾಡೋಣ, ಅಲ್ಲಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ. ಅಲ್ಲಿ ರಿಪೋರ್ಟ್
ಲಿಸ್ಟ್ 2 13ನೇ ಮ್ಯಾಟ್ರ್ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್. ಲಿಸ್ಟ್ 2 13 MG ರವೀಶಾ ಅಂತ ಬರುತ್ತೆ ನಮ್ ಸೀನಿಯರ್.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಶನ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಟುಮಾರೋ.
ನಾಳೆನಾ?
ನಾಳೆ ಬಂದು ಅಪಿಯರ್ ಆಗಿ ಕೂತಿರಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೇಳ್ತೀನಿ ಮೇಡಮ್.
ಎಲ್ಲ ಇಲ್ಲಿದೆ ನಿಂದು ಡೇಟ್ ಇರೋದೆಲ್ಲ ಕೊಟ್ಟಿದ್ಯಾ ಅಲ್ವೇನಮ್ಮ?
ಅವತ್ತು ಏನು ಕತೆ?
ಮೇಡಮ್ ಸಿಗ್ನೇಚರ್
ಮಾಡಿದ್ದಾರೆ.
Okay.
Not filed basing on the NSA.
Basing on that. ನೋಡ್ಲಿಲ್ಲ ಎಲ್ಲ ಹೋಗಿ 12:30 ನಂಬರ್ ಆಗಿರೋದು ಫೈಲ್ 4 ಗಂಟೆ ತಪ್ಪಿಸಿದ ಬೆಂಗಳೂರು ಕಷ್ಟಪಟ್ಟು
Serial number 17. What do you like about?
ಕಂಪ್ಯೂಟರ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಹೇಳೋಣ ನೋಡಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲ ಕ್ಲೈಂಟ್ಸ್ ಇವಾಗ ಕೂತ್ಕೊಂಡು ಅಲ್ಲೇ
ನೀವು ಇಲ್ಲಿ ಇಟ್ಟಿರೋದ್ರಲ್ಲಂತೂ ಒಂದು ಇರ್ಲಿಲ್ಲ. ನಾನು ಚೆಕ್ ಮಾಡ್ತೇನೆ.
Serial number.
ನಾವು ಅವಾಗ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ, ಬರ್ತಾ ಇಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂ ಇದೆ ಅಂದ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ಬೇಕು?
ಅದಕ್ಕೆ ಅವತ್ತು ವಿಸಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬೇಕು.
ಇವಾಗ
ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು.
ನಾನು ಈಗ ಮಾಡಿದ್ರೆ
On technical issue, all the advocates are requested to appear physically. ಅಂತ ಒಂದು ನೋಟ್ ಹಾಕ್ಬಿಟ್ಟು ವೆಬ್ ಪೋಸ್ಟ್ ಮಾಡಬೇಕು.
ನಾನು ಇವಾಗಲ ನಾನು ಅದೇ ಅನ್ಕೊಂಡೆ ಒಂದು ಹಾಕ್ಬಿಡೋಣ ಟೆಕ್ನಿಕಲ್
ಆ ಥರ ಏನಾದ್ರು ಮಿಸ್ಟೇಕ್ ಆಗ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್. ಫೈಲ್ಸ್ ಅರ್ಧ ದಿನ ಇಲ್ಲ ಅಂದ್ರೆ ಫೈಲ್ಸ್ ಇದೆ. ಅಲ್ಲ ಅದು ಹೊಟ್ಟೋಯ್ತು ನೋಡು. ಅದೇನೋ ಟೆಕ್ನಿಕಲ್ ಇತ್ತು ಅಂತಪ್ಪ. ಬೆಳಗ್ಗೆಯಿಂದ ಕಸಿ ನಾನು ಕದ್ದು ಕೊಟ್ಟು ಹೇಳಿ ಆಯ್ತು. ಅದಕ್ಕಿಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿಸ್ಕೊಂಡು ಕರೆಕ್ಟ್ ಆಗಿ ಅದೇನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಟೈಮ್ ಕನ್ಸಂಪ್ಷನ್ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಅನ್ಕೊಂಡು ಅದನ್ನು ಕಷ್ಟ. ನೀನು ಅದನ್ನ ನೀಟಾಗಿ ಟೈಪ್ ಮಾಡಿದ್ರೆ
Lordships kindly 25 serial number, list number 1, my lordships. You are both are agreed for 1,50,000, it may be disposed of. I appear for respondent.
The Passover matter.
Passover, yes, ma'am.
Passover matters, serial number 6. Satisha T. For appellant, yes, Nirmala.
Present the appellant in this case. It is the claimant's appeal.
Where is Nirmala?
Appearing to VC in the morning. Now she is not there, ma'am.
In this matter, fairly submitting you before your lordship. Actually, the claim petition of the claimant has been dismissed. Fairly submitting before this honorable court, the charge sheet copies were not produced, nor the spot master, nor the all other charge sheet annexures were not produced. The honorable trial court, based upon the said lacuna, has dismissed the claimant petition. My grievances before this court is that if I have been provided an opportunity to produce all those documents.
Accident is of which year?
It is of the year 2011, year lordship, 2011. I'm fairly submitting before this court. Now also
That can't be granted now.
Now also before this court, my humble request is that if this court provides me a 2 or 3 weeks, I will make a last attempt to secure that documents which are not being produced and file.
Could have done it from 2016 at least. We are in 25 now.
To
After
be
9 years, why should again adjournment on that?
to be fair, my colleague Satish T is handling the case. He said that he's out of station, is not able to attend the case. That's the reason I came up before the court, and I'm making a submission which is, I'm a referring counsel to him. I'm making a submission which is fairly before this court. If this court provides me a 2 or 3 weeks time, I'll make a last attempt of that. So if this court finds that there is no proper.
We will dismiss this case in the presence of the advocate on record. When will he come?
After 1 week here.
This is matter on Thursday in the same caption. Yes, at the request of non-counsel for the holiday, Wednesday.
Much obliged.
Yes.
Till number 22. Till number 22.
Time for the appellant, my lord. It's a case of injury, my lord. Liability fixed against the owner of the vehicle, my lord.
You are only on that liability issue?
My lord, because of the, my lord, insurance policy was not in force.
No, you're only on that issue? Only on liability?
Yes, no, my lord. For enhancement also, my lord, the liability.
Case of injury?
A case of injury, my lord.
On what ground, the insurance company is exonerated?
My lord, as per exhibit R1 to R5, my lord, at the time of incident, my lord, the policy is not in force because, my lord, the owner of the vehicle issued a check for the insurance policy, my lord, and the check was dishonored. Because of that reason, my lord, the insurance policy was not in force, my lord. Because of that, my lord, the owner liability fixed against the owner of the vehicle, respondent number 1, my lord.
So when was the check issued?
My lord, check was issued on 11/7/2003, my lord.
2003.
Towards the insurance policy, my
Because
lord.
when was it dishonored?
25/8/2003.
25/8?
2003, my lord.
When was the accident?
Accident 19/2/2004.
19?
2004.
When it was intimated to the owner of the vehicle?
My lord, the respondent number 1 purchased the vehicle, my lord. This, the intimation is.
Registration is changed, your lordship. This is the originally Maharashtra vehicle. It is come to the Karnataka Judicial. They changed the number also. They changed the ownership. And also policy in between almost all cancelled because he has bounced. He has not given the intimation to the next owner. Is a cancellation of policy. Anyhow, here it is the bounden duty of the present owner to do the policy for present. And registration also number is changed. Maharashtra vehicle come to the KA02 like this, your lordship. And detail evidence has been given by the insurance company and produce the documents also.
So how the
My lord.
insurance company is liable?
My lord, registration changed, my lord. I am the next owner, my lord. And the insurance company not intimate to me, my lord. The owner of the respondent number 1 ಗೆ intimate, it intimated to the earlier owner.
Yes.
My lord, I am the third party, my lord. I pass a judgment.
How can I go on with the changing?
Let's see what is the judgment.
Hello, whatever it may be, my lordship.
May I permitted to read, my lord? Second para, my lord. This appeal is heard by the bench 3 judges because the learned counsel for the appellant, the Oriental Insurance Company, has submitted that the decision of this court in United India versus Ayab Mohammed had been misread by the Motor Vehicle Claim Tribunal and the High Court, and while the appellant would pay the amount of compensation awarded in this matter, it desired, in view of the general importance of the question, an authoritative pronouncement. For the purpose of this appeal, therefore, very few facts and relevant. A bus met with an accident. Its policy of insurance was issued by the appellant on 30th November 1989. The premium for the policy was paid by check. The check was dishonored. A letter stating that it had been dishonored was sent by the appellant to the insured on 23rd January 1990. The letter claimed that as the check had not been encashed, the premium on the policy had not been received, and that therefore the appellant was not at risk. The premium was paid in cash on 2nd May 1990. In the meantime, on 90th April 1990, the accident took place. The bus collided with the truck, whose driver died. The truck driver, widow, and minor son filed a claim petition. The appellant denied the claim, asserting under the term of Section 64 VB of the Insurance Act, no risk was assumed by an insurer unless the premium thereon had been received in advance. The Motor Accident Claim Tribunal rejected the appellant contention and awarded the claimant's compensation in the sum of ₹96 with interest. My lord, kindly come to para 7, my lord.
Your case will not fall. These facts and the facts of the case will not apply to you. That is a case where the check was issued, it dishonored,
and after that, my lord.
In between the accident has occurred.
Yes, my lord.
In that case.
Yes,
and
my
as on that day, the policy was there. At a later point of time, they have dishonored, they have cancelled it because
by the cash, my lord, they.
Yours is, that's why I asked for you the dates.
Yes, my lord.
11/7/2003 is the check, dishonored on 25/8.
Yes, my lord.
Accident has taken place on 19/2/2004.
2004, my lord.
By the time the policy is cancelled.
Yes, my lordship.
There is no policy as on that day.
No, my lord, because of
And it
the-
is already intimated to the owner.
my
and
lord,
as-
it's not
Not
intimated
yes.
to the respondent number one, my lord.
Not a case, not a case. Please come.
And my lord, for the enhancement, my lord,
Let's hear the enhance.
my lord,
Owner is served.
Yes, your lordship.
owner is liable.
Please come to
Served
the
and
order.
represented.
Please come to the order.
My lord, accident occurred on 19/2/2004.
Which page, discussion, issue number 2.
Issue number 5, my lord.
Please come to that.
Running page number 19.
What are the injuries?
My lord, injuries lacerated injury over the left little finger, lacerated injury 2 into 1 bone deep over the finger.
So 3 simple injuries
And one grievous injury, little finger amputated, my lord. Doctor stated, my lord, 30% disability to her little finger. And my lord, since she is a minor, my lord, the loss of earning was not taken, my lord. The future loss of income.
Little finger was amputated.
Yes, my lordship. Little finger was amputated. 9 years girl, my lord.
What is that judgment?
Yes, my lordship. In V. Macaulay versus Malati, my lord, 17 years minor, my lord, the student. However, my lord, Supreme Court taken 10,000 notional income and give compensation under the loss of future income, my lord. May I permit it to read, my lord, head note?
Which para?
My lord, in the head note itself, my lord.
Not head note, come to the paragraph. Para 20.
Yes, my lord. Therefore, in the light of the principle laid down in the aforesaid case, it would be just and proper for the court, and keeping in mind her past result, we take rupees 10,000 her monthly notional income for computation of just and reasonable compensation under the head of loss of income. Further, the High Court has failed to take into consideration the future prospectus of income based on the principle laid down by this court in the catena of cases referred to supra. Therefore, the appellant is justified in seeking for enhancement under this head, as well as we hold that the appellant claimant is entitled to rupees 50% increase under this head as per the principle laid down in this court.
This other judgment,
My lord, another
in
judgment. my
case
lord,
of minor, she is 9 years old.
This is the coordinate bench of this honorable court judgment, my lord. In this case, my lord, the 14-year minor child.
She is 9 years old.
Yes, my lord, it's a 10-year.
Give her.
Lord, in this case, my lord, this coordinate bench of this honorable court, my lord, consider the Mekale versus Malati and consider the future loss of income head, my lord, and 10,000 notional income was taken by the court, my lord. In running page number 14, para 16, my lord. Notional income 7,000 was taken, my lord.
Then why this Mallikarjun's case is not applicable?
My lord, Mallikarjun case and my lord, the Mekale versus Malati case, the same year. my
That
lord.
case is 17 or 18 years old.
But my lord, it's both are the same year, my lord, and this case.
Not about the year, it's about the age.
Yes, my lordship. My lord, it's a 10-year girl, my lord, student. The same facts, my lord, and loss of income, future loss of income, my lord, was taken by the.
Is Mr. Krishna Swami?
Cases will be utilized, the two. Finger is amputated. And if it is compared with Workmen's Compensation Act, for an index finger, it is 14%. Entire finger is amputated. But here it appears doctor has given 30% or 32%.
30% to the.
For finger,
That
whole
may
body
be-
he has not given.
That may be an exaggerated.
Yes. That's
Whole
why
body is taken, it will be around
that's
3 to
why-
5%.
criminal has discussed it. He has not given the whole body. That's why he has taken this one. Doctor kindly see this. Moreover, doctor has
So in these-
categorically stated.
No, in these cases, how should the notional, the income be decided?
Per annum that way they will taken the notional income.
No. What is, in Mallikarjun's case, what is decided?
That is,
Master Mallikarjun.
Master
Mallikarjun
Mallikarjun
case
case
is,
went only with regard to the percentage of disability.
And
calculated,
accordingly, they have,
not in terms of income, notional income was not decided,
not taken.
not taken.
only global
They've
compensation.
given a standard, if it is
Standard.
10%.
Yes.
This
30%.
percentage, so much would be the loss.
Hmm.
That is inclusive of pain and suffering and everything.
Everything. There is
Except in some court,
medical
expenses are also
has to be
included.
included.
Medical expenses are included.
That could be included.
It is here medical expenses is very, because 2004 accident.
So in which case, even for the age of 9 also, they have taken the notional income?
Kajal case. Kajal.
The Kajal's case is a case where it is a permanent disability, not able
But
to.
income assessed only by notional income to minimum wages.
So that is a case where a completely, the girl is paralyzed.
Vegetative.
Normally with regard to income, paragraph 21 says notional income to be taken, minimum wages to of that day. Minimum wages of that day to be taken. That is paragraph
Yes.
20.
It is 2003. Go back to 2003, it will be.
Minimum wages, that is the.
Well, let's assess for the global and you can.
2,400 rupees was the minimum wage, even in 2003.
2003.
As per the WC.
We don't have a chart for that.
There is a chart, in fact. Airports, we had a chart.
No, that is, it appears from 2008.
18 ಆಗಿದೆ ಹಿಂದೆ ಇಲ್ಲ.
Minimum wages. is
Minimum
the
wages.
The legal premises of
Of that day.
Minimum wages it will start 2005.
No, for the
Because
2004 to Ramchandrapa's case is which year?
2004
Eight.
or 6. Supreme Court took.
Ramchandrapa's case, they've taken 4,500
For a able-bodied
person. In case of
Because
a farmer.
WC is 2000 is only the 2000 they have taken on 2004.
My lord,
And then 4000 they made it. Amended the whole.
Accident is which year?
2004.
4.
Then 4,500 can be taken.
Like because after the 2006 and 7 is 4500 taken. But even 4000 is the minimum for WC also. On 2004.
4,000.
4000 only.
WC is different.
That is different, but amount is the same, no? Currency.
So it's a 30% to the whole body.
30% to the,
Limb they have given. Whole body they have not given. Your lordship can ascertain.
So it would be 10%.
Yes.
To the whole body.
Yes.
Please, ma'am. So taking income at 4,000 into 12, 18.
4800 is the 10%.
What is that?
10%. 4800 is per annum. It will come. $4,000 into 12. 48,000.
It comes to 86,400.
That count.
Yes, my lord.
It comes to 86,400.
My lord, and the pain and suffering and the other.
1 minute. This is loss of future.
In other rates, because
Where is
chart
table?
table is page number. Your
My
lordship,
lord, running page number
that is
23.
16.
Para 22.
22, 16. On those days it is correct, your lordship, because 2004 accident.
Let's just see.
Running page number 23, judgment page number 16, my lord.
Para 22. General.
How many days he was in hospital?
6 days, my lord. From 19 to 2004 to 24 to 2004.
coming to 2,03,900. It comes to 2,03,900. Please, madam. Please come. Agreed with the orders passed. MBC number 641 of 2004. Dated 26 November 2014. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 2,20,000 for the injuries sustained by the claimant in the accident that occurred on 19/2/2004. It's a case of the claimant that on 19/2/2004, the claimant was traveling in an auto rickshaw. When the said auto rickshaw came near Jamatikatta, today at about 8:45 AM, a Maruti car driven by its driver came in a rash and negligent manner and dashed against his auto rickshaw. As a result, he sustained grievous injuries and immediately was shifted to Gandhi Hospital, where took treatment as inpatient, discharged on 24/2/2004. The claimant is the injured, the injured is a minor. And because of the injuries, the little finger is amputated. As per the wound certificate, there are 3 simple injuries and 1 previous injury. When it comes to the liability, the tribunal has held that as on the date of the accident, the vehicle was not having an vehicle is not insured. There is no valid insurance policy. As such, the insurance company is not liable to pay the compensation. And the owner alone is liable to pay. And the accident has happened due to the rash and negligent driving of the driver of the offending vehicle. Then when it comes to the compensation, towards spinal suffering, an amount of rupees 15,000 is offered. Towards loss of amenities in life, 25,000. Medical expenses, 9,500. Loss of education, career, 10,000. Loss of marriage prospects, 10,000. Conveyance, food, nourishment. Then it becomes 2,13,000. Loss of marriage prospects and happiness. Conveyance, food and nourishment, 500. Altogether, an amount of rupees 74,500 is granted. Aggrieved thereby, the claimant is before this court. Then counsel appearing for the claimant submits that the check was issued on 11/7/2003 and it was dishonored on 25/8/2003. Accident occurred on 9/2/2004. The dishonor of the check was not informed to the owner of the vehicle, and the claimant being the third party, still the insurance company is liable to pay the compensation. In that regard, he is relying on the judgment of the apex court in case of in case of Oriental Insurance Company Limited versus Inderjeet Kaur, reported in Law SC 1997, 1242. Relying on this judgment, it is submitted that the insurance company is still liable to pay the compensation, and the court had has exonerated the insurance company. Next, coming to the coming to the enhancement of compensation, it is stated that when the girl is aged about 9 years and her left finger is little finger is amputated, which would have an impact on her life. And the court had failed to grant any amount, granted only an amount of 15,000 towards pain and suffering and towards loss of future earning, no amount is granted. Even under all other heads also, the amount that is granted by the tribunal is on the lower side. She had relied on the judgment of the apex court, B. Mekala versus N. Malati and others, reported in 2014-11 SCC 178, and a judgment of a coordinate bench of this court in MFA number 4396 of 2016 and MFA number 3208 of 2016 in case of Managing Director of Bangalore Metropolitan Transport Corporation and Master Azam Pasha. It is submitted that the notional income was taken at 10,000.
In Supreme Court judgment, my lord, 10,000, and the coordinate bench, my lord, 7,000.
Where 10,000 and 7,000 were respectively taken by the apex court. In this court, it is submitted that the petitioner is also entitled for the trial court has not given a just and reasonable compensation, and as such, compensation needs to be enhanced. Then counsel for the appearing for the insurance company submits that the judgment of the apex court in Oriental Insurance Company referred to supra do not apply to the facts and circumstances of the case. In fact, they have immediately informed about the dishonor and the cancellation of the policy to the first owner, and later the vehicle was sold and the registration was changed, and as such, as there was no valid insurance policy as on that day, the owner of the vehicle is liable to pay the compensation. Rightly, the tribunal has exonerated the insurance company from the liability. Next, though the notice is served on the owner of the vehicle, there is no wakalat is filed on his behalf. Next paragraph. Having heard the counsels on either side, produce the material on record. First, coming to the aspect of liability, the accident had taken place on 19/2/2004. The dishonor of check was on 25/8/2003. After this check was given by the owner for the person who has purchased or who has purchased the owner or the first owner. Thereafter, it was sold, and by the time to the respondent herein, and by the time the check was dishonored, and according to the insurance company, it was already informed to the original owner. It is the contention of the land counsel for the claimant that it was not communicated to the second owner. As such, as the petitioner being a third party, the insurance company is liable. This contention, this court is not able to accept. And the judgment of the apex court in Oriental Insurance Company Limited, referred to supra, do not apply to the facts and circumstances of the case. Where in that case, the accident has happened from in that case, the dishonor of the check and the intimation to the owner of the vehicle in between the accident has occurred. And in this case, the facts are totally different. And the tribunal had rightly held that the insurance company is not liable to pay the compensation, and rightly held that the owner alone is liable. On that count, the order needs no interference. Then coming to the quantum of compensation, considering that the girl of 9 years had met with an accident and there is an amputation of the left finger, the little finger, under the caption of pain and suffering, this court is granting an amount of rupees 40,000. Towards loss of amenities in life, 30,000, considering the injuries. Medical expenses, court below had granted 9,500. This court do not find any reason to interfere with the same. Coming to the loss of education and the marriage prospects, an amount of rupees 10,000 each is granted. On that count also, this court is not interfering. Coming to the convenience, food and nourishment, this court is granting an amount of rupees 10,000. Then under the head of loss of income to the parents, no amount is granted. Hence an amount of rupees 8,000 is granted. Coming to the loss of future earning, the tribunal had not granted any amount. This accident had taken place in the year 2011, considering the notional income at 4,000. And the disability to the limb is 30%, and to the whole body, it comes to 10,000, 10%. Then 4,000 to 12 into 18 into 10 by 100 is 86,400. Next, in the light of the law laid down in so-and-so, the claimant is entitled to the legal expenses of 10,000. Altogether, the claimant is entitled for an amount of rupees 2,13,900 accordingly. The appeal of the claimant is partly allowed by enhancing the compensation from 74,500 to 2,13,900. The compensation amount shall be, the owner of the vehicle is liable to pay the compensation.
Respondent one here. Respondent one is directed to.
Respondent one?
He is owner.
The respondent one, owner of the vehicle, is liable to pay the compensation.
Much obliged.
Cell number 25. If there are for petitioner SB exam.
Should I accept for the respondent?
Yes.
1,50,000 global money in addition to what is awarded by the tribunal.
1,50,000.
50,000. Including interest.
Including?
Interest.
The workman is before this court agreed with a compensation of an amount of 2,11,300 granted by the court below. When the matter came up, land counsel appearing before counsel appearing, both the parties submits that the parties have arrived at a compromise and the insurance company has agreed to pay and the petitioner has agreed to receive an amount of rupees 1,50,000
Yes.
in addition to what is granted by the trial court, including the interest. Considering the submission of both the parties, the appeal is disposed of and the insurance company is liable to pay an amount of rupees 1,50,000 in addition to 2,11,300, including the interest. Accordingly disposed.
Cell number 26. Ramesh KR.
In this matter, my lord, I am appearing for the appellant. My lord, the claimant appeal.
I am for the respondent number 2, my lord.
The claim petition was dismissed. My lord,
On the ground?
my lord, the ground that my lord, the appellant herein is not proved the negligence and rational negligence of the driver of the deceased.
Let's come to the discussion.
My lord, please, my lord. For a moment, my lord, issue number 1 is concerned, but the trial court is come to error in this issue number 1. May I read the issue number 1 first, my lord, in this matter. Whether the petitioner proved that on 23/2014 at about 12:15 AM after attending the marriage function from the friend, the petitioner as a pillar rider and his friends D. Ravikumar were returning from this vehicle in his motorbike bearing number KA06X9235 and Tumkur Kotigere Road near Akshaya College. The unknown vehicle which came to in rash and negligence manner and dashed against
You
the
can come to
petitioner.
reasons.
Please, my lord.
Number 1.
Reason number 1, my lord, para number 9, my lord. It is the specific condition of the petitioners that on 23/2014 at about 12:15 AM when he was along with his friend D. Ravikumar were returning from the Kodigere after attending the marriage function on the motorbike bearing number KA06X9235 on Tumkur Kodigere Road near Akshaya College in the Tumkur Road. Some unknown vehicle came in the rash, high speed and rash and negligence manner and dashed against the petitioner and caused the accident. It is also a specific case of the petitioners that in the accident rider of the bike, D. Ravikumar died on spot and the petitioner sustained grievous injury and Therefore, the material proposed facts has been specified denied by this.
Yes.
Your Lordships, I appear for second respondent, my lord. The matter requires reconsideration, my lord. He was a plane rider, my lord. He sustained injury and rider of the vehicle died in the accident, my lord.
He's arguing. You said something in between. That's why I'm looking at you.
No, my
He
lord,
has
I'm
not
sorry, my
completed
lord.
his argument.
I'm sorry, my lord.
Fractures, this material proposed as facts has been specified denied by the respondent number 2. Therefore, the petition is required to prove this issue. Para number 10. In order to prove his issue, petitioner Deepak laid his evidence as a PW1. In his evidence has clearly stated that the manner in which was accident occurred on the date. And perusal of the contents, the exhibit P1 to exhibit P5, that is exhibit P1 FIR complaint, exhibit P2 charge sheet, exhibit P3 Panchnama, exhibit P4 own certificate, exhibit P5 EMB report. It is observed that the police case against the driver of the unknown vehicle in crime number 40/2014 on Kora police station for the offense punishable under section 273, 337 and 304A of IPC and section 134A and B and 184 of EMB Act. Later, the police have filed a C final report stating that the accused driver who caused the accident and he has valid vehicle not traced out. This document clearly shows that the driver of the unknown vehicle as driving his vehicle in the rash and negligence manner and dashed against the petitioner and caused the accident. These documents are also not in dispute by the second respondent insurance company, but they have specifically stated that the accident is not occurred due to the rash and negligence driving of the motor vehicle by the deceased D. Ravi Kumar and the alleged date of accident. In addition to those facts, PW1 is evidence also clearly stated that the accident occurred due to the it is important, my lord. In PW1 is evidence also clearly stated that accident occurred due to the rash and negligence driver of the unknown vehicle. It is pertinent to note that the driver regarding this accident, the respondent number 1, Devraj, who is father of the deceased D. Ravi Kumar, has filed a complaint with the.
I think I'm not able to understand. They say unknown vehicle.
Please, my lord.
Then why this unknown now suddenly at issue number 1 K06X9235 has come into picture?
My lord, the present vehicle involved in the accident, the petitioner is a pillion rider. The rider is a D. Ravi Kumar.
Oh, this is K06 is on the vehicle in which you are.
Please, I am proceeding in the vehicle.
Oh.
Please. It is pertinent to note that regarding this accident is respondent number 1, Devraj, who is the father of the deceased. The father of the deceased was given a complaint, my lord. The deceased Ravi Kumar has filed a complaint with the police. In the complaint has also clearly stated that the unknown vehicle was coming high speed, rash and negligence manner, dashed against the motorcycle and of his son and caused accident. Therefore, the version of the complaint is supported by the FIR, complaint, C report, spot measure, and MV report, which was marked exhibit P1 to P5 in this case. Therefore, without my conclusion, I can safely come to conclusion that the accident occurred caused due to rash and negligence driver of the unknown vehicle. Even I gone through the evidence of the PWM, which is contains the exhibit P4 wound certificate showing so far as injury is concerned, and perusal of the exhibit P4, it is appears that on the date of accident itself, as this complaint was hospitalized at government hospital Tumkur, and there are medical documents has also shown that subsequently.
Para 14.
Please.
Para 14.
Please. Para number 30.
Para 14.
Please. Therefore, on perusal of the evidence of PW1, RW1, and document exhibit P1 to P5, it is clearly that the unknown vehicle came in rash negligence manner hit to the motorcycle bearing number K06ZX9235, and which the present petitioner and the deceased Ravi Kumar was traveling, and due to the impact, the rider died on the spot. The petitioner sustained grievous injury. Therefore, the police records which was produced and marked by the complaint in support of his case indicates that the motorcycle which the complaint was traveling in the meet with accident and unknown vehicle. The same are recorded in the all documents, that is Panchnama, FIR, C report issued by in respect of the alleged accident. In this case, it is on record that an unknown vehicle hit the motorcycle on the accident on which he was.
Opponents.
But the respondent is, my lord, the owner of the vehicle and the insurance.
Which vehicle?
My lord, the appellant traveling in the vehicle. My lord, the date of accident, please, my lord, for a moment, my lord, the date of.
So,
Please, ma'am.
the entire evidence is because of the rash and negligent driving of the unknown vehicle, this accident has happened.
My
All
lord,
the medical records are in that.
my lord, it is not medical records, my lord, based on
The
police
police
records.
records are there.
Based on the police records, my lord, the trial court come to conclusion that, my lord, the vehicle was, the present vehicle is not, accident is not in dispute. My lord, the trial court not heard the conclusion that, my lord, in my evidence, in my petition, I clearly stated that the driver of the vehicle, my lord, I am traveling the vehicle, is himself also negligent to rash and negligence.
That it's a petition filed under 166. You have to prove his negligence.
Please, my lord.
All the records show that it is because of the negligence of the offending vehicle.
My lord, because of the police records, my lord, based on the police records, my lord, come to conclusion, my lord, trial court.
But that's what, some of, either of it.
My lord,
should be
even
there.
though, my lord, the charge sheet is filed, is not a conclusion proof, because sometimes, my lord, except my contention is this, my lord. My lord, the appellant is the only eyewitness of the.
Let's forget about the charge sheet and all other things.
Please, my lord.
What is the evidence that you have placed before the court to show
My lord,
that the rider of the vehicle is at fault?
My lord, I will, my lord, I am the eyewitness of the accident. As on the date of accident,
That
it is
that
midnight.
itself is
My lord, I will state it in the claim petition and my evidence also. But, my lord, the trial court, my lord, not taken contention and issue regarding that, my lord.
Your self-serving statement itself is not
My
sufficient.
lord, except the, my lord, my.
There are other evidence on record
my lord,
contrary to that.
The date of accident, at that time was accident, my lord, midnight. There is no evidence.
Because you cannot claim the compensation against an unknown vehicle.
My lord,
And
I am not claiming unknown vehicle, my lord. I am claiming the vehicle involved in the accident.
That's why you
I am
claiming
traveling the said vehicle also.
That's why you're claiming compensation against the bike,
Bike.
which is available. And you have, for claiming compensation, you have to prove negligence, which you cannot, which you have failed to.
My lord, the trial court was error regarding this point is concerned, my lord. For a moment, my lord, and that reason, my lord, I will point out, my lord, issue regarding, my lord, the trial court raised an issue. They have not proved the accident. My lord, the finding, my lord, stated that, my lord, the appellant is not proved the negligence and the driver who deceased as on the date of accident. My lord, in my evidence, I am the eyewitness at the time of accident. No other witness was examined. My lord, based on the C report filed by the police, my lord, the trial court come to conclusion.
File a complaint saying that because of the negligence.
My lord, I am admitted on, my lord, that point is concerned, my lord, on date of accident on 3/23/2014. My lord, I admitted at the time of accident.
Later.
My lord, the father of the deceased was given a complaint. And that reason, my lord, I will state it in my evidence on my claim petition before the trial court, my lord.
Please come.
My lord.
Agreed with orders passed in MBC number 1689 of 2014 dated.
My one submission, my lord. I will give one fair opportunity was given to the appellant. My lord, I will convert to present petition 166. I will file before the trial court. May permit to 163A. It is required for me
Yes,
to.
Mr. Counsel. Respondent.
Otherwise, my lord.
Your Lordship, sufficient opportunity was granted for them to convert the petition, my lord. Even otherwise, my lord, the income prescribed under section 163 is 40,000 per annum. The tribunal has observed that even if it is converted, they will not get the compensation.
What is your income according to you?
My lord, as per month, my lord, I have a salary holder 6,000 per month as on the date of accident.
So it will be?
72,000.
That also then that conversion is not permissible in the light of the judgment. What is the judgment? Bandar is something?
My lord, principle of natural
Conversion.
Deepal Girish by
my lord,
Sony.
grievous injury is there, my lord.
Deepal Girish. Milord has also passed an order in this regard.
That's what is that judgment?
Deepal Girish by Sony, Milord.
Deepak Girish by Sony.
But there is a serious injuries. At least, my lord, convert to
What
163.
to do? Agreed with the orders passed in MBC number 1689 of 2014 dated 12 July 2017, whereby the tribunal has dismissed the claim petition. The claimant is before this court. It is a case of the claimant that on 23/2014 at about 12 AM, when the appellant and his friend were returning from Kottagiri, after attending marriage function of their friend on the motorbike, when they came near Akshaya College in Tumkur Taluk, some unknown vehicle came in a high-speed, rash and negligent manner and dashed against the petitioner and caused the accident. Your own pleadings. Sir.
In my pleading also, my lord, I have stated in future and next, my lord, that
It can't, either it will be that or this, it can't be both. Either rash and negligent driving of
unknown vehicle himself or the driver of the disease also, my lord, I have stated.
and dashed against the petitioner and caused accident. Due to the accident, rider of the bike died on the spot, and the claimant, who was valiant rider, suffered fatal injuries. After the accident, the driver of the unknown vehicle fled away from the spot, and the petitioner was immediately shifted to the government hospital. The court has given a finding that the medical record, the police records and other records reveal that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. The claim petition is filed by the claimant seeking compensation against the owner and insurer of the bike. The claimant could not substantiate his claim that the deceased rider of the bike is at fault, and because of his negligence, the accident had happened. The court had, and the petition is filed under 166 of the Motor Vehicles Act. The court had dismissed the claim petition. Next parallel, and counsel appearing for the appellant claimant submits that the petitioner claim, the appellant claimant is an eyewitness and being a pillion rider who had sustained the injuries. His evidence is consistent with regard to the negligent, rash and negligent driving of the rider of the vehicle. And the court had failed to consider the said evidence. And the court had relied more on the police records than the evidence that is placed by the claimant. It is submitted that if an opportunity is given, he would convert this petition under section 163A of the Motor Vehicles Act. Then counsel appearing for the respondent insurance company submits that the court had rightly considered the evidence on record and rightly dismissed the claim petition as the claimant had failed to prove the negligence on the part of the deceased, who was the rider of the motorcycle. He further submits that question of converting the petition under 163A does not arise as the income is above 40,000. Income of the appellant is above 40,000.
Your Lordship, one more submission, my lord. Your Lordship, they have option to approach the state under section 163(1) and hit and run cases. Solatium scheme, they can seek for compensation from state.
What is that?
163(1), they can seek the compensation from state. In injury cases, it is 25,000. In hit and run cases, my lord.
But no, he is neither here nor there.
Your Lordship, he can approach your Lordship.
No, he is not saying that the unknown vehicle has, it's not a hit and run case. According to him, it's because of the rider of the vehicle.
But as per the police records, my lord, it is
that liberty will grant.
Your Lordship, that may be reserved to them.
Having heard the grounds for the petition for the submission on record. The specific case of the claimant is that because of the rash and negligent driving of the offending vehicle, the bike met with an accident on which he is a pillion rider. And thereafter, it is also stated in the very same claim petition that the rider of the vehicle is at fault, and because of his negligence, the accident had happened. The tribunal had considered all the evidence available on record, and then came to the conclusion that the accident had and has come to the conclusion that the claimant had failed to prove that there is negligence on the part of the claimant.
Negligence on the part of the deceased.
There is negligence on the part of the rider of the vehicle, the rider of the bike on which the appellant is a claimant. All the police records clearly shows that an unknown vehicle had, and because of the negligence of the driver of the unknown vehicle, the accident has occurred, and the rider of the vehicle had died in the accident, and the pillion rider had sustained injuries. When the petition is filed under 166 of the Motor Vehicles Act, the burden lies on the claimant, which we failed to discharge in this case. And the court had rightly held that is not entitled for any compensation. Then the second argument of the land counsel with regard to converting the same under 163A in the light of the apex court judgment in Deepak Girish Bhai Soni.
2004 ACJ 934 Mila.
What is that?
2004 ACJ 934.
2004 ACJ 934. When the income is above 40,000, or there is no option even to confine that income and plead the relief, seek the relief under section 163A. Even on that count also, the petitioner fails to succeed. What is that you're saying? Counsel for the incident. You said something.
Section 163(1) Solatium scheme.
He is not entitled to amend the same to 163A. However, under section 160?
163(1), my lord.
163(1), what is that?
The Solatium scheme.
Solatium scheme under the hit and run cases. They are entitled for compensation. The petitioner is entitled for the same. He can approach the appropriate authority.
Obliged.
List number 2, serial
Much
number
obliged.
19.
Petition counsel. The present petition arises under the execution proceedings, my lord. My application under Order 21 Rule 97, with section 151, it is the court below, the learned judge has dismissed the application without going into the contents of the documents what we presented before the court and without conducting an inquiry. The mandate of the view of the apex court is, if there is that is independent to the right and title interest of the judgmentator after if that had to be gone into inquiry by the under Order 21 Rule 97, as your lordship knows. That is in fact just a point out from the Order 21 Rule 97. Your lordship kindly appreciate the resistance to delivery, possession to decree order or purchase, resistance of obstruction to possession of immovable property, where the order of a decree for the possession of immovable property or the purchaser of any such property sold in execution is resisted or obstructed by any person in obtaining the property, he may make an application to the court complaining of such resistance or obstruction. Where an application is made under sub-rule 1, the court shall proceed to adjudicate upon the application in accordance with the provision herein contained. What I try to pursue further, Your Lordship, 101 is also relevant. Question to be determined, Your Lordship, kindly. All questions, including questions relating to right, Your Lordship, what I try to point out, all questions, including questions relating to right, title, or interest in the property arising between the party to a proceeding on an application.
Before going into the rule provision, please tell the facts of the case.
The facts of the case is this, my lord. Your Lordship, kindly, now there is the present, there is the suit is filed by an objector. with, that is in, I produced the copy of the file in 2012, my lord. May I request, my lord, on applying that you page at your lordship kindly, the present suit, annexure D may be kindly be seen, my lord. Page 65. That is the present objector, that is P. Balaji, in OS number 2254 of 2012. Page 65, my lord. 65.
55.
65. Annexure D, my lord. 65.
Hmm.
The one by P. Balaji in OS number 2254 of 2012. Your lordship may kindly may request, my lord, the para 4 of my plaint I am interested to point out, my lordship. Only para 4 of
What is the suit for?
suit is for a declaration. Your lordship may kindly page at prayer at 71.
Yes.
Prayer in the 2012 suit. Wherefore the plaintiff prays for a judgment and decree declaring that the registered general power of attorney executed by the first defendant in favor of M. Papanna dated 25/4/1980 registered as a document in the office of the sub-registrar Bangalore South Ali is one for consideration and irritable. Consequently, direct the defendant 1 and 2 to execute the sale deed of scheduled property in favor of the plaintiffs and defendants 3 to 5 jointly. Defendant 2 is the decree holder. Here, my lord, the second defendant, the Bharati Muralidhar, is the decree holder. The present where the execution proceedings filed. I am not a party to the said.
No, that I understood.
Yes, sir.
Defendant cannot be a decree holder.
But
This,
it is a suit filed by me. This suit is pending consideration.
no, let's not go to this. But execution proceedings are arising out of which suit?
In HRC, HRRP, that is your lordship, and the Karnataka Rent Control Act.
Let's see, where is that decree?
That is under section
Shall I
40 down.
pass on and, events which I have taken?
Please, please.
Your lordship, kindly, for section 46, the present petition is filed. The HRC proceedings are initiated.
Take that.
Annexure B may be kindly be seen, ma'am. Annexure B, page, your lordship, kindly, I request my lord to page 35.
Let's see the chronology of events.
Yes,
What has been given by them?
35. It is an HRC eviction order. I am not a party to this.
The whole of the list starts from my father. I am the
No,
second.
1 minute, give 1 minute. I'll just look at the events,
Yes.
what you have said. What is the objector's name?
Objector name is Balaji. Lordship, my application may be kindly be seen. Your lordship, may I request.
I'll look into it.
Annexure E, page 74.
Your-
Yeah.
P.
Annex-
Balaji.
Annexure E, along with
P.
my.
Balaji.
Yes.
Yes, the P. P. Balaji.
The
Your
last
Lakshmi-
but one, that is filed on 9/10/24.
Your Lakshmi, kindly appreciate the point for consideration, my lord.
Minute, I'll just complete this and I'll ask.
Right.
What is your client's name?
My client Bharti Muralidhar.
Your client is Bharati Muralidhar.
She's the owner of the property.
So what is your right with
My-
respect to this property?
Yes, your lordship is right. Now, it is an admittedly, the suit is pending consideration from 2012. My first submission, the point for consideration before the learned judge, before the court below, they, without going to the merits of the application and without going to the contents of the document placed before before the learned judge, and without conducting an inquiry, you will actually kindly appreciate what under order 21 rule 97 contemplate 2797 to 101 is let him conduct an inquiry and let him pass any order, and I am not coming in the way. And without going into the merits of the documents, and 17 documents as placed. May I request, my lord, the learned judge's impugned order at annexure A, page 18. The learned judge says, my lord,
What is your, how you're setting up an independent title? How you're setting up an independent title, your client?
yes, exactly. Your lordship, there is a registered GPA, irrevocable GPA, before a consideration in favor of my father.
Your
That is
father's name
Papanna.
is Papanna.
Papanna, my.
And Papanna.
That is in the, you will
No,
also
no.
kindly appreciate 28/4/1980 is the registered GPA dated. Registered GPA coupled with interest for a certain amount consideration.
25/11/1995.
28/4/1980, we are put in possession.
No. 25/11/1995. Papanna died.
Yes, yes, exact. I'm not disputing.
No, your father died.
My father died.
Oh.
Now, what I tried is a coupled with interest. You are 202 of the Contract Act, where it says, my lord, and that is the heritable. Your lordship kindly appreciate. Termination of an agency, 202, my lord. Before and during my father's lifetime, and they never terminated the general power of attorney, registered general power of attorney. By virtue of a registered general power of attorney, and by virtue of an agreement of sale, I am put in possession, and there is no, I put up the construction, I am residing. That is my specific case before the trial court in 2012 for a declaration based on certain, all readings have been placed, all documents are placed. Just I'll read for your lordship kind consideration. The 202, termination of agency, where agent has an interest in subject matter, where the agent has himself an interest in the property, which forms the subject matter of agency, the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. What the section 202 is of the Contract Act is, Lordship kindly, they appreciate. One down here, my lord, my case is, it is undisputed. Let the learned judge go into all these aspects. Whether there is a 2012, there is a suit is pending. You will ask me kindly draw a time limit. I am prepared to assist the court.
Yes, let's come, please come to the impugned order. Let's come, let's see.
You are
Lord, if
Annexure
I am
A may be
appointed, I
kind
will point out the facts in a chronological
Annexure
order.
A.
That will be easy for your lordship.
So that I understood.
You
No,
will
I
ask me
understood the.
kindly, annexure A may be kind of page 18, my lord. The order of the learned judge. May I request, my lord, order of the learned judge start from page 20. A number 8, your lordship
Let's
kindly.
read from page 21 from the reasoning part.
Yes, no, that's why before that I try to only one para 2 may be kindly within. Para
Yes,
2 of the order of the on 9/10/2024 along with IA8 That is why Balaji get filed 17 documents. Your Lakshmi kindly 17 documents, including copy of the plaint pertaining to OS 2254 of 2012, pending in CVT Civil Court, Portal 36. And the reasons your lot starts at the paragraph. First, yes, I start my reasons, your Lakshmi kindly. The reason, point number 1. In the lengthy argument, learned advocate appearing for the applicant of IA number 8, Balaji, by analyzing the evidence available in the file, requested to allow IA 8 relying upon the following judgment. In the lengthy argument, learned advocate appearing for the decree order, by analyzing the evidence available in the file, requested to reject IA 8 by relying upon the judgment on dated 24/6/2020 passed in WP GMCPC, that is the and Karan. On 21/1 to para 12. On 21/1/2005, learned advocate appearing for the applicant IA 8 filed the following judgments. In the light of the judgment cited above, with reference to the submission made on behalf of both the parties, I have appreciated the material available in the file. In the lengthy affidavit filed in support of IA 8, Balaji asserting filing of the OS 2254 of 2012 against Y. Ramaya and the present the donee holder of Bharati Marulidhar, and seeking a relief of declaration that the registered GPA dated 28/4/1980 executed by Ramaya, father of decree holder Bharati Marulidhar, in favor of Papana, the father, is one for consideration coupled with interest, which is heritable, and to consequently to direct the defendant one to execute a sale deed in favor of the plaintiff Balaji and defendant 3 to 5, including the Lakshmi, sister-in-law Balaji jointly. Balaji asserted that the site number 234, Koramangala, was allotted in favor of Y. Ramaya, the son of Adu, who, after execution of the lease cum sale agreement and possession certificate, executed the registered irrevocable GPA in favor of Papan, which is binding on the present decree holder, who is a daughter of Ramaya. The applicant Balaji asserted the Y. Ramaya, son of appointed Papana, as the power of attorney holder to manage the site 234, and as the Ramaya executed the GPA in favor of Papana for consideration. The applicant Balaji further asserted that on the basis of the registered power of attorney executed by Ramaya in favor of Papana, Papana ensured all negotiations with BDA and obtained kata, paid taxes in the respect of 234 and acquired possession property, and put up a construction by obtaining the sanction plan during 1982-83. On 25/11/1998, Papana expired. Thereafter, Balaji continued in possession of the site, and he let out the ground floor portion premise to Era interiors. Balaji further asserted that initially Papana, thereafter Balaji continued in possession and enjoyment the dispute.
Now, when an
The
application,
reasons started from here.
Mr. Senior Counsel, 1 minute. When an application is filed under Order 21 Rule 97, is it not the duty of the court to adjudicate it and give give a authoritative, give a pronouncement on that?
With due respect, I may have to differ. The reason I may have to differ, there need not be any inquiry. If prima facie, if they show that they are.
No, not inquiry. What is that the court is saying that IA number filed by the so-and-so is hereby rejected for what ground?
No documents are ever produced to show his independent right, my lord. My lord, the facts are like this. He is the second objector in that execution proceedings. He is not the first objector. My lord, the judgment debtor is none other than his sister-in-law.
No, that I understand.
What happened
is this
was-
finding? I'm not able to, when it comes to the penultimate paragraph.
Yes.
From para number 31.
Yes.
Is neither believable nor acceptable nor sustainable.
Lord, he has to show prima facie that he is in possession of the property under an independent right. Merely filing an application and saying that I am an interested.
So what should be the finding of the court?
The finding of the court is.
Finding of the court should be, he's not setting up an independent title.
No, he is setting up an independent right. He says that I am in possession and I have let out to a person what he has produced before the court, a lease deed of the year 2023. 2023, the eviction proceedings.
So where is that finding? That he doesn't fall under any of the provision under order 21 rule 97.
Lord, I will just point out.
May permit me to place the site and the decision of the effect court.
No, no.
No, first let's have the things.
Lord, shall I start from para 23, page 26?
No, I have seen all that. Those
Yes.
are all discussions about that, this page, that paper, this document, this only discussion.
Lord, there the learned judge comes to the conclusion that his possession, even if true, it is during the pendency of the proceedings. It is not prior to the proceedings. That's what para 23A, the learned judge holds that.
Unfortunately, what is discussion, what is order, nothing is, one is
Lord,
not
the
able to
only thing
understand
is
from
that the earlier objector by name one Uday Kumar, who he contended that he is a tenant under the judgment debtor. That is Srimati what is Lakshmi Srinivas, the second respondent before your lordship. And he filed an application. There he did not produce any document. That went on for 2 years. Thereafter, that was dismissed by the very same judge, the learned judge. And thereafter, immediately this person comes and says, I am interested. That Uday Kumar comes and says that I am in possession, I am a tenant. He produces a copy of the lease deed from the second respondent, who was the judgment debtor there. He produces that and says that I am in possession. That lease deed is also of the year 2015. After the disposal, during the pendency of the HRRP filed by the tenant. And now the elder brother's wife, the Balaji's elder brother's wife is Lakshmi Srinivas. She was the tenant in that by virtue of a lease agreement executed by her father-in-law. That is a lease agreement. If you are lordship, I will pass on a copy of the documents. That will make things clear. Everything will be clear. Sorry, sir. Lord, if your lordship would kindly see page 8 of that document. This is the lease deed executed by Papanna, is none other than the father of this Balaji. Page 8. Exhibit, it is shown as exhibit P7. Why Ramaya is my father, first respondent's father, the son of inter-alia so and so, represented by GPA holder Sri Papanna, son of Muniswami. He was the power of attorney holder of my father, Papanna.
So Srinivas is another son of Papanna.
First son of Papanna. So Srinivas and Lakshmi, son and daughter-in-law, were given tenancy, were given on rent.
No, a suit is filed by Balaji. In that, this Srinivas and Papanna are also parties.
Srinivas was not alive. He died even prior to me.
Lakshmi?
Lakshmi is alive. She is the second respondent.
I'm asking.
In that suit also, she is a party.
She is arrayed as?
She is arrayed as the third respondent also. Third defendant.
Lakshmi is arrived as a third respondent.
Third defendant.
Third defendant.
What happened was, by virtue of this deed of lease, which is executed by my father through the power of attorney holder, I initiated eviction proceedings in HRC 207 of 2011. That proceedings went on, and in 2013, it ended in 2014. Then HRRP was filed. That was in 2014, HRC was disposed of. That was, it is held that she is liable to be evicted. Then HRRP was filed by that very lady who is the tenant. And in that HRRP also I succeeded. That order is passed on 13/12/2021. HRRP 87.
No, it is a claim of this Balaji.
Yes.
That in the light of the GPA that is granted in his
Yes.
favor, in
That-
favor of his father, he is
Yes.
in possession of the property.
That is what he says. His father died in 95, not 98 as shown here.
When this HRRP is filed?
2011. 2011, after the death of her father.
When that attained finality, when the final proceedings with regard to the rent control.
Lord, HRC ended
No, from, I think chronology you must have mentioned.
That is, my lord,
2020.
11/8/2011, HRC 207 of 2011 was filed by me.
11/8/2011.
11/8/2011. Then immediately thereafter, this Balaji files this OS, the next one.
No, what he says in that suit about his possession and all other
He
things.
says the same thing. I am in possession. That's all. That's what he says. But it
In
is,
that suit, Lakshmi, has she filed a written statement?
yes, she has filed a written
What did she
statement.
say?
She says that she is the tenant there. She is the owner of the, she says she is the owner of the property.
So she denies his title.
Yes,
Hmm.
she is the owner of the property. She contends there. And taking advantage of these things, they are on hand in glove, Lord. What happened was,
No, no, I'm sorry.
one second. I will just,
At this stage itself, I'm very clear. I am not in handing glove. I have nothing to do with Vide.
I will point out, my lord. I will point out even that aspect.
So you will ask with permission of my learned friend. 2012 itself, I am very clear. The suit is filed, he is also on knowledge about it. And if at all, if really interested, you would have added to the said suit itself. Which so that in fact you could allow me to contest the HRRP. The whole reason behind the scene is, my lord, if at all, if there is the only it is a special statute, as your lordship knows. Rent control is a special statute. So far, if dual relationship with landlord and tenant, then only the question remains with the rent control act.
Why were you not pursuing your suit for declaration?
The evidence is the matter is posted for defendant evidence, and they are also cross-examined. And
2012 suit.
Their suit will house.
It is his suit.
No, no.
That's what I'm saying, your suit.
My lord, they did not pursue it.
I am
But
pursuing.
I will make one point clear, my lord. In suit is filed in 2012. This suit was filed on 11/4/2012. I filed my written statement. That is the first respondent before your lordship. Filed my written statement 15/11/2012. In my written statement, I have stated that he has nothing to do with the property, and that I have already initiated eviction proceedings in HRC 207 of 2011. That is pending. I have stated that in that case, in my written statement. Yes, no, that's I have produced now. If you are page 26.
2021, on 9/10/2021, HRRP is filed by Lakshmi Srinivas.
Yes,
And
madam.
on 13/12/2021 was dismissed.
Dismissed.
Then you have filed the execution on 14/6/2021.
Yes, madam. Thereafter, Lakshmi Srinivas, that is the second respondent before your lordship, who is the judgment debtor there. She files an objection in the execution saying that I am not in possession of the property. I have already let out to one Uday Kumar. And through him, she gets filed as an objector there. That Uday Kumar comes there and says, I am in possession.
And that is also dismissed.
That is, he came in possession according to them only. It is 2015.
With respect to first floor.
2015. During the pendency of the proceedings before this honorable, before the High Court. Then that application was dragged on for 2 years. Thereafter, it was dismissed. Now the second person has come. He is not satisfied with his presence there. He has also set up his tenant, another third person.
No.
Yes, I will give this one. That is also filed. This application by name Sheikh Zahir Abbas, it is filed. And he contends that, and this man also says that I have let out to Sheikh Zahir Abbas. That is in 2023.
He also filed a claim petition.
Yes, he has also filed a claim petition. Even that is pending adjudication now. He is the third person. That copy, your lordship may kindly peruse this copy.
No.
Take that.
This is my copy. I have already filed objection to that also.
He made me as a defendant, and then the whole question. Now here, my lord, the learned judge, we are inquiring into the issue relating to my correctness of my.
And that person also says he is my landlord. And he says that he is his tenant. And the tenancy has commenced in 2023. And the proceedings is of the year 2011. And it is not as if he did not know about the pendency of this HRC 207. In my written statement filed on 15/11/2012 in that OS 2254.
I understood that.
I have stated that about the initiation of proceedings in HRC 2011 on the file of the small class judge Bangalore.
Yes, understood. It was telecom.
And
my
one more submission.
What? Yeah.
Not that only HRC proceedings was initiated. There was another 2 suits filed by this judgment debtor. That is the second respondent, Lakshmi Srinivas. One for injunction and another for declaration that she is the absolute owner of the property. 2 suits were filed. They are OS 6794, that events I have mentioned, that OS 6794 of 2007 connected with OS 7952 of 2006. Those two, in that suit, she comes and says, the suit agreement is only is executed as a security for the loan given by my father-in-law. So an agreement of sale was executed as a security for the loan which is given to Ramayana. That is what even that evidence I have produced before your eyes. So in that, those suits were also came to be dismissed. And he knows everything. And he says he's deciding in the adjacent portion, not that he is deciding elsewhere. In the adjacent property, he is residing. And he comes now in 2023 or 24, he comes and says that I am in possession. He is the second applicant. The third applicant is also is now going on.
Yes, Mr. Senior Counsel.
The point, short point, my lord, what I try to pursue here, the important point for the consideration of the learned judge is whether your Lakshmi kindly, that's why I read the paragraph 2 of the order of the learned judge. He says that 17 documents are produced. See what the scope of the section order 21 rule 97 as your lordship, I try to, why I am pointed out is, here my lord, let the, in your Lakshmi, even at this stage, your Lakshmi, I am prepared to assist the court below and I will cooperate with the court. Your Lordship, if I draw a 30 days or a 2 months, I am prepared to assist the court below and let there be an inquiry. Whether I am really there is an agreement of sale or the registered GPA coupled with interest or a genuinity, whether the possession.
All that will be decided in your suit.
Yes, exactly. Your Lordship kindly appreciate.
All
Order
that
to be, you know, why I am telling you. Here, the scope of Order 21 rule 97 is it has to be construed as a decree. That is the whole difficulty is here, my lord. That's why I am taking, my lord, to the decision of the Supreme Court on the division bench of this court and the same set of facts. Just I'll point out, my lord, your Lordship may kindly appreciate the scope of section Order 21 rule 97. May I request, my lord, to first the decision.
So before that, now you have filed a suit saying
Yes,
that basing on a GPA that is executed
Exactly.
in favor of your father.
Yes, I am.
Now, whether by virtue of that GPA, whether you are the owner of the property or not will be decided by the court in the due course. That this court cannot, the executing court will not go into all that. And your possession, if you are in possession of the property, if somebody is interfering, because when they have filed a written statement and they have clearly stated that somebody else is in possession of the property, you have nothing to do, and HRC is pending before the court. What action did you take?
No. That is the so far my friend's submission with respect to the possession is concerned, my lord. Here the ground floor is I am in possession, my lord. The first floor, the statement filed by so I am nothing to do with I am not a party in that case. Even no. Now HRRP, I am not a party in the HRC.
Not HRRP, Mr. Senior Counsel. You have filed a suit.
Yes,
You have filed a suit seeking declaration.
Yes, exactly.
In that, he filed a written statement. In the written statement, he has categorically stated that the so-and-so is in possession of the property. You have nothing to do. And your sister-in-law has also filed a written statement stating that you have nothing to do. So you have a knowledge about a pending HRC where it is stated that somebody else is in possession. What did you do from 2012?
That is the HRC with respect to it because of why they filed a HRC proceedings. If there is a jural relationship, if there is a relationship of a landlord and tenant, then only the special statute attracts. Here,
if you are genuinely prosecuting the litigation, the moment somebody files a written statement and tells
I can't implead in the set case.
You should know definitely you can file in that I am the owner of the property. It is nothing to do with them.
Here, my specific case it is the undisputed fact. The third respondent is contesting the case, and in fact, we have taken all participated in the proceedings. You like me kindly appreciate why I try to suppose if my possession I do agree the reasons by assigned by the learned judge. I do agree with the scope of inquiry under 21 Rule 97. If they would have gone into the 70, we referred the document of 17 documents. He never discussed as to what exactly the document, what exactly the plain copy, or a title, or the 17 documents placed before the learned judge.
What are the 17 documents?
17 documents. I produced all the 17 documents, a copy of it.
Please give that.
But that is available in the file on the previous.
Yes. We will see all the 17 documents. Yes.
I have to seek the possession in the main suit itself, if such is the case, if suppose assuming I am being thrown out from the real property, if by virtue of an order of eviction, certainly I have to again I have to go before in the said suit for ask for a possession. No, it is your life may kindly hear. You will let the learned judge will look into all these documents, whether my plaint is placed before the court below, my agreement of irrevocable power of attorney is placed before the court below, and that is not the reason assigned by the learned judge. In fact, your life may kindly entire, if you read, it is not a detailed reasons order is not been, there is no reasons as such. That is specifically along with my application, your life may kindly appreciate Annexure E, page at 74. My application order 21 Rule 97 may be kindly be shown. Your last may, I referred all these documents in my affidavit itself. Along with my filing an application, these are the documents. The construction is made by, in fact, construction was after obtaining the plan and license. I put up the construction. My father, I am residing there, and as this ground floor has let out to the. This is a specific case of the the present petition. You will ask me why I am trying here. You will ask me what the scope of Order 21 Rule 97 may be kindly be seen. That just I will refer one or two judgments. I am not taking only the relevant part. You will ask me kindly appreciate the ratio of the law laid down by the apex court, the scope of Order 21 Rule 97. I am not providing much. You will ask me kindly.
2003 10 SCC.
Yes, first judgment, my lord, 2003, para 16, my lord. Para 13 and 16. Check for your lordship reference. For the purpose of considering an application order 21 Rule 99, and what was required to be considered was to whether the applicant herein claimed a right independent of the judgment letter or not. A person claiming through or under the judgment letter may be dispossessed in execution of a decree passed against the judgment letter, but not when he is in possession of the premises in question in his own independent right or otherwise. To further, para 16. To further, the question for others consider whether the disputed premises was within the tenanted in the event of the High Court and Section 50 of the Constitution. We may observe the finding of based on the oral and evidence. And next, further, my lord, 2002, para 8. You will ask me kindly, para 8, 19, and 20. Para 2002 of the Supreme Court, 166.
Para number?
Para, you will ask me kindly, para 8 and para 19 and 20, my lord. Just I'll read, my lord. The para 8, page that the relevant provisions of CPC material for the case of Rules 97 to 103, the Code of 97 provides, where the holder of a decree for the possession of a movable property or the purchase or any obtaining a possession of the property, he make an application to the court complying of such resistance or obstruction. Such as an application dealt with by the court in accordance with the provision contained in the court. Now the further, my lord, the paragraph 19 is relevant. Internal page 117, my lord. From the principles laid down in the decision,
yes.
From the principles laid down in the decision noted above, the position is manifest that when any person claiming title to the property in his possession obstruct the attempts by the decree holder to dispossess him from the said property by executing court is competent to consider all questions raised by the person suffering obstruction against execution of the decree and pass appropriate order which under provisions of order 21 Rule 103 is treated as a decree. So Lakshmi kindly, it is treated as a decree. From the averments made in the petition, quite opponent before the executing court, it is clear they are claiming independent right to the property. From they are sought to evict execution of the decree. It is for the further of the complaint that the right in the property had vested in them much prior to the filing of the present suit for the next is to be kept in mind. Next, my lord, the 2000 part 10 SCC 405 para 3, my lord. Your lordship may kindly appreciate. In view of the obstruction, so called it was for the decree holder to take appropriate steps under Order 21 Rule 97 to removal of obstruction and to have the rights of the parties, including the obstruction, adjudicated under the provisions of Order 21 Rule 101. We do not know if any such proceedings have been taken by decree order, whether such proceedings are pending or not. The appellant, however, made various applications, including the present application. Now, the next judgment, my lord, can we tell you? Yes. Sorry. The last judgment division being in the same set of facts, page 59 may be kindly within. Para 17 and 18, last same similar circumstance, the same facts. Yes. May I request, my lord, the page 59, internal page, and that is paragraph 17, 18, 20. 17 may I'll read one.
Yes.
Yeah. Your Lordship, kindly referring in the case of Sitara loan current city and 1969 Supreme Court, the Honorable Apex Court has observed there is hardly any doubt that the given appellant in a favor of a bank is a power coupled with interest. That is a clear both from the tenor of the document as well as from its term. Section 2 of the Contract Act provides that where the agent has himself an interest in the property, which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice to such interest. It is settled that where the agency is created with a valuable consideration, authority is given an effective security or to secure interest agent, the authority cannot be revoked. The document itself says that the power given to the bank is irrevocable. It must be said fairness, and the Chagala that he did not contest the finding of the High Court that the power in question was irrevocable. Para 18, my lord. In an agreement and it's entered the paragraph 20, my lord.
Yes.
Page 78. Your Lordship may kindly appreciate and try to, where the agency is created for a valuable consideration, an authority is given to effectuate the security or to secure the interest of the agent. The authority cannot be revoked. Section 202 of the contract reads thus, your Lordship. Illustration. A gives authority to B to sell A's land and to pay himself out of the proceeds the debts due to him from A. A cannot revoke his authority, nor can terminate it by insanity or death. So, Lordship, what I try to para the death. As per the said provision, if the agency is coupled with interest, it is irrevocable. From the reading of the illustration, it is clear that if the authority is coupled with interest, principles cannot be revoked the authority, nor it can be terminated in insanity or death. Therefore, even after the death of the principal, the agent can act on the basis of the said authority. Therefore, general power of attorney executed in favor of Lakshmi Shur, that has been exhibit P23, read as irrevocable power of attorney as it is coupled with interest. What I try to pursue, this is the same arising under rent control proceedings only. This is the same set of facts. Now, your Lordship, may I request, my lord, my GPA is page at 6 and 9 of my list of documents. Your Lordship,
It will be going to that now. The validity of the GPA, why would the court look? For that, you have already filed a suit.
Yes, I filed a suit.
That the
In
court will decide
2012,
it,
that is a pending for adjudication.
court will say that the rent control court will not go into all these
No, that is
aspects.
in fact, in the specific prayer in the statutory, that is to direction to execute the sale deed in favor of me by 2 and 3. That is the specific prayer in the prayer and the. But the point here, my lord, the executing court must consider the what exactly where I stand and what are the documents or the 17 documents. He would have given an opportunity. Let the trial court would have given an opportunity. Let the inquiry. You will ask me kindly fix the date and time Let the inquiry may be completed within 30 days, as your lordship, whatever the circumstance, what your lordship, then the facts and circumstance of the case, let the inquiry, till the inquiry, let them pass any order and let them, I will demonstrate before the court whether my independent right, I have got a right or not. That is the title or possessing or not. That is whether the possession is with me or not. Now, these are the question. In the court, I mean, bailiff Shara shows I am in physical possession of the property. Even now, that is the Shara of the what before the Shara shown in the executive court that shows I am in physical possession.
Is it so?
No, my lord. They only say that he is obstructing, that's all, nothing else. Not that he is in possession.
What is the necessity? If such is the case, I am not in possession. Your lordship, I will produce the audit sheet of the court below and the Shara of the bailiff to show the physical possession with the petitioner. What I try to pursue here, my lord, is the whole object of Order 21, Rule 97, and ultimately even the Bescom bill, even the present electricity bill stands in the name of my father, Papanna. And even today I produce the documents, nearly 17 documents I placed, the 17 documents to show I am in, even today I am in possession. Your lordship, ultimately, my lord, assuming for an argument's sake, if your lordship, if the court below, if considers and say I am not in possession, or the whatever the suit is pending considers, what exactly the legality and correctness ultimately for the adjudication of the case in controversy, see whether the documents placed before the inquiry court, and let an inquiry. Your lordship, ultimately the object of Order 21 Rule 97 to 2000, that is 101. Ultimately the court had to give an opportunity to go into the contents of the merits of the document and whether I may really possess the independent right or title or not. Ultimately, here, my lord, is without assigning any reason, the learned judge referring in Uday Kumar, I have nothing to do with.
No, once an order is passed rejecting your application under Order 21 Rule 97, then what should lie against that?
Your lordship kindly remand the matter and let your lordship directly. 1 minute, you allow me to make much. Your lordship directly learned judge to inquire into the issue within 30 days.
That's not the question I asked. When an application is filed.
It is an appealable order.
Then how
It is an
come this is
appealable
filed?
order. Because since it has come arisen out of an HRC proceedings in which that's what under that notion my learned friend has filed.
No,
That
whether it is arising out of the rent control proceedings or not, in an execution petition, you have obstructed the execution.
Yes.
And filed an application under 21 Rule 97.
It is an
Any
appealable
order
order.
that is passed by the court has to be treated as a decree.
Yes.
And it is an appealable order, a regular first appeal.
That's
lies
the law.
against that.
That is the law.
If I do, it has to be construed as a decree. Your lordship is right. In fact, what your lordship is suppose if my application for obstruction is not, yes, that is now it's a executing court, as your lordship has rightly said, it rejects. If I thrown out from the very purpose will be defeated, till my possession may be protected.
No, how can it be? You cannot come before a court where when you have a right of an appeal, a regular appeal, you should go
Here,
before.
my lord, I am in the right of appeal only arises, the question is, if it is a decree under the declaration.
Whether it is rejected or entertained, it is a judgment under decree.
No,
It
here,
has-
my lord, the scope, no, your lordship kindly, I try to pursue here is Order 21 Rule 97. That is your lordship kindly for all the executing court go into all aspects.
Correct. Now whether it is.
Lord, hitherto the argument was that is an appealable order only.
It is arising out of HRC proceedings. And execution is initiated in the HRC proceedings. We have to file HRRP, which is in parameter to appeal filed against the OSDP. Against an order we suffer under an HRC proceedings, HRRP will let.
No, a court of an HRRP will decide about the legality of what is that, a GPA, whether you have an independent right or title to the property or not, it will be decided.
HRRP proceedings lie before this honorable. we cannot file an RFA because the first objection will be raised is proceedings arising out of Rent Control Act. RFA is not maintained.
Though it is arising out of the Rent Control Act, you are setting up your title there. If you're setting up your title there, that has to be decided.
Because since the other include would be arising out of small causes court.
No, it is like, now the court has to, it's a continuation of the suit proceedings. A regular first appeal is continuation of the suit proceedings. Now this court would be dealing with all that.
Small causes court, that is, if it was a regular court, then appeal would be. But since it is a small causes court which has passed the order, HRR, which is to be treated in a manner of appeal.
We'll pass orders, please come. Agreed with orders passed in execution number 683 of 2022, dated 6 February 2025. The objector is before this court. The respondent herein, which is for the first respondent herein has the first respondent herein has filed HRC number 207 of 2021 against
2011.
11 against the, which respondent is
Second respondent before.
against the second respondent, and that came to be
Decreed
allowed,
on
that came to be decreed on 28, 2014. Against that, the second respondent herein had preferred the HRRP on 9/10/2014. That came to be dismissed on 13/12/2021. Thereafter, the execution petition is execution 683 of
It must be 22, my lord.
2021.
I'm sorry, there is some mistake.
execution of 683 of 2021.
It
was
must be 22, my lord, 22.
22.
May I add one sentence, ma'am? Your Lordship may kindly, the whole pith and substance is, my lord. The executing court shall adjudicate the issue, so far the issue in controversy. There were letter are under the scope of Part 21 Rule 97 and the review of all the ratio decision of the court is, ultimately the executing court can adjudicate the issue and whatever the view, let them take. And your Lordship kindly remand for the reconsideration.
That's a submission you made, Mr. Senior Counsel. I've made a note of it. I may have noted note of
There
it
is a
and
coordinate
keep
bench.
it.
There is a
Yes.
decision of this, a coordinate bench of this honorable court that no evidence need be adduced.
Yes.
That is what,
What did you write? Execution petition 683 of 2022 was filed by the first respondent herein. Then she filed her objections to the execution petition on 14/9/2022. Thereafter, the petitioner before this court had filed the IA under Order 21 Rule 97. It is a specific case of the petitioner before this court is that the father of the father of the first respondent has executed a irrevocable general power of attorney in favor of the father of the petitioner on 25/4/1980. Then the father died on 25/11/1995. They have been in possession of the property and they have made constructions. When on 11/4/2012, he has filed OS number 2254 of 2012 against the first respondent herein and her father.
also against the second respondent.
And also against the second respondent. And the said suit is pending adjudication. before the executing court, he has filed as many as 16 documents. Those are copy of the lease cum sale agreement dated 7/7/1979, copy of the sale agreement dated 1/8/97, the copy of the irrevocable GPA 25/4/1980, copy of the tax paid received two in numbers, the copy of death certificate of Papana, the copy of the application for transfer of kata, the copy of the possession certificate, the copy of the electricity bill paid receipts, photographs, the copy of the plaintiff in OS number 2254 of 2012, the copy of the written statement of defendant number 1 and 2 in OS number 2254 of 2012, the copy of the written statement of defendant number 3 and 4 in OS number 2254, the copy of the issues and additional issues in OS number 2254 of 2012, and the document, the copy of the examination in chief of BW1 in OS number 2254 of 2012, and the copy of the sale deed dated 10/7/2006, and the copy of the gift deed dated 17/7/2006. Basing on these documents, it is a case of the objector that is the owner of the and who is in occupation of the property, and without impleading him as a decree is obtained and that decree cannot be executed. The trial court, by order impugned, had rejected the said application filed under Order 21 Rule 97. While rejecting the application, the court has observed that since 2012, the objector and his sister are conducting OS number 2254 of 2012, and on behalf of the judge are conducting OS number 2254 of 2012 for and on behalf of the judgment debtor under children against Ramaya on the basis of the registered GPA dated 25/4/1980, a registered document number and the registered GPA dated 25/4/1980. The evidence on record shows that after conducting inquiry, HRC came to be decreed, which has been confirmed by the order dated 13/12/2021, passed in HRRP number 87 of 2014. The court records a finding that the judgment debtor Lakshmi Srinivas, applicant of IA number 2, Uday Kumar, and the present applicant, that is applicant in IA number 8, are asserting possession over the disputed premises in different capacities. Hence, it is clear that Balaji and company, in different methods, making several attempts to avoid decree holder to take possession of the disputed premises in terms of the order and decree passed in HRC number 207 of 2011, confirmed through order passed by the court and passed by the High Court in HRRP number 87 of 2014. The court also observes that the allegations made in the affidavit filed in support of IA number 8 by the objector is not supported by admissible and believable evidence. In view of the pendency of OS number 2254 of 2012 before the competent authority, at this stage, it is neither permissible nor possible to express any opinion about validity consequences of the GPA dated 25/4/1980, alleged to have been executed by Ramaya, executed by Ramaya. Balaji and the objector and the legal representatives of Papana are having absolute liberty to get suitable relief in OS number 2254 of 2012. And court came to the conclusion that the submissions made on behalf of the objector is neither believable nor acceptable nor sustainable for grant of relief as sought in the application in I number 8 and accordingly rejected the application. And further directed to issue possession warrant, directing and authorizing the process branch to take possession of the property prescribed in the schedule of the decree passed in HRC number 207 of 2011 from judgment debtor and hand over the same to the decree holder in accordance with law. Agreed thereby, the objector is before this court. Litigant counsel appearing on behalf of the objector submits that the scope of inquiry under Order 21 Rule 97 is clear, and any judgment and any order that is passed by the court in an application under Order 21 Rule 97 is treated as a decree, and against that a regular appeal lies against the same. It is submitted that when an application is filed, it's a duty of the court to conduct the inquiry and to pass an appropriate order. He submits that he has filed, the objector has filed as many as 17 documents, including the copy of the plate. And the court had failed to do any inquiry as contemplated under Order 21 Rule 97. As he is setting up an independent title, and the court ought to have considered all the documents and ought to have given a reasoned order with regard to the right of the objector. He has drawn the attention of the court to the order passed by the court below and submits that no such inquiry is conducted by the court as contemplated under Order 21 Rule 97. It is submitted that if the order impugned is set aside and the matter is remanded back to the trial court, and a direction may be given to the trial court to pass orders in a time frame, and the petitioner will cooperate with the same, and it would be in the interest of all the parties. With regard to the scope of inquiry under Order 21 Rule 97, he had relied on the judgments of the apex court and reported in 2003 10 SEC 449, 2002 1 SEC 662, 2010 SEC 405, 1995 1 SEC 242, ILR 2008 Karnataka 3553, 2017 SEC Online Delhi 8694, 2002 SEC 50, and also a judgment of the of this court, of this division bench judgment of this court, and MFA number 22850 of 2013 with regard to the Section 202 of the Contract Act. Relying on all these judgments, senior counsel submits that the executing court had failed to exercise the jurisdiction vested with it, and the order impugned needs to be set aside. Next para. Learned counsel appearing for the respondent number one. Learned counsel appearing for the respondent number 1 submits that they have filed the HRC against one Lakshmi Srinivas, who is the second respondent herein, and who is none other than the sister-in-law of the petitioner herein on 11/8/2011. She is the father of the objector, and who is the father-in-law of Srimati Lakshmi Srinivas, has executed a lease deed in favor of her, and basing on that, she is residing in the said property. And for her eviction, they have filed HRC number 207 of 2011. That came to be, then after the said suit is filed by them on 11/4/2012, OS number 2254 of 2012 is filed by the present objector against the respondent, first respondent, second respondent, and the first respondent's father, that is Y. Ramaya. In that, on 15/11/2012, a written statement was filed by the first respondent herein and also the second respondent. In the written statement of the first respondent, it is stated that the plaintiff, that is the objector and the plaintiff in the said suit, has nothing to do with the suit scheduled property, and second respondent, the property is leased out to the second respondent herein, and in respect of this, already HRC number 207 of 2011 is filed, and the second respondent herein, who is the sister-in-law, has denied the title of the plaintiff, that is objector herein, and also herein, and also stated that she is in possession of the property. Then counsel submits that when the plaintiff, when the objector is aware of the pending proceedings right from the year 2011 till 2022, he kept quiet. Then when the execution proceedings are initiated, one Uday Kumar has filed an application under Order 21 Rule 97. According to said Uday Kumar, he is the tenant of Lakshmi Srinivas. Then that came to be dismissed on 21/9/2023. 21/8/2024. That came to be dismissed on 21/8/2024. Thereafter, on 9/10/2024, the present, what is the other you are saying? Sheikh Zahir.
Yes, now it is pending.
Thereafter, the objector has filed.
Another objector.
Then the objector has filed the present IA under Order 21 Rule 97 on 9/10/2024. Then counsel further submits that thereafter another IA came to be filed by one Sheikh Zahir Abdul.
Yes.
Sheikh Abdul.
Zahir Abdul. I have produced that.
Sheikh Zahir Abdul, stating that Sheikh Zahir Abbas, stating that he is a tenant of the present objector, and the said petition is pending adjudication. It is submitted that though the HRC is filed in the year 2011, till today, though in 2022, they could, the proceedings have attained finality. Still now, or in collusion with the judgment debtor, they're coming up with one petition after the other. He submits that either for the judgment, to the judgment debtor, as well to the petitioner, to the petitioner objector, they are relying upon their source of title is the GPA that is granted to Ramaya. What is this? Papana, lease agreement, that is the GPA that is granted to Papana, and basing on that GPA, he has executed a lease agreement in favor of his daughter-in-law. Daughter-in-law, that is the second respondent. He submits that the court had considered the claim and whether it is an independent claim or not, and whether it falls within the scope of Order 21 Rule 97, and having come to the conclusion that it requires no further inquiry, and prima facie it requires no inquiry, court has rightly dismissed. Court had rightly rejected the application, and there are no grounds to interfere with the well considered order passed by the court. Next paragraph. Having heard the learned counsels on either side, then senior counsel for the petitioner, objector, and the counsel for the respondent number one, this court has perused the material available on record. The HRC proceedings that are initiated by the first respondent herein have attained finality on 13/12/2021, when HRRP 87 of 2014 filed by the second respondent herein was dismissed. Thereafter, the execution proceedings are initiated. The judgment debtor is none other than the sister-in-law of the objector herein, who is the petitioner herein. Now, he is relying upon a GPA that is executed by the father of the first respondent herein.
Father-in-law.
Yours, sir.
Yes, my father, first respondent's father.
The father of the first respondent. Father of the first respondent in favor of the father of the objector. Even the judgment debtor that is also relying on a lease deed that is executed by her father-in-law in her favor, basing on the GPA that is executed by the first respondent's father in the favor of her father-in-law. Now, all that this court has perused, all the documents that is exhibit, the documents that are filed along with an application under Order 21 Rule 97. Those documents are the GPA and all other documents pertaining to the suit that is OS number 2254 of 2012. The suit is filed in the year 2012, where he is seeking a declaration.
Specific performance.
Seeking a specific performance. And
Declaration and specific performance. Unspecific
declaration and specific performance. The said suit is pending from 2012. He is seeking declaration basing and he is asserting his title basing on the GPA. That will be decided by a competent court in a comprehensive suit filed for declaration. Now, in these execution proceedings, the petitions, the obstruction, the petitions that are filed by the objectors, that is by Uday Kumar, by the present petitioner, and by another Sheikh Zahir Abbas, all these clearly shows that with one way or the other to stop to interfere with the process of execution, these petitions are filed one after the other. The rights of this petitioner, this objector, can only be decided by the competent court in OS number 2254 of 2012, but not by the executing court in these proceedings. It is not even the case that this objector is not aware of the pending proceedings that are initiated in the year 2012, as the written statement that is filed by him, that he has filed before the court, the written statement filed by the first respondent in OS number 2254 of 2012. The trial court, considering all these aspects, had rightly observed that the court cannot it is not for the court to make any observation with regard to the GPA that is executed in favor of the objector's father, and it has to be decided by the competent court in the pending suit between the parties. The court had rightly rejected the application of the objector. It is the submission of the learned senior counsel that all the exhibits were not considered, all the documents that are filed by the objector were not considered by the court. This court has already perused the documents that are placed before the court. Though the trial court has rightly considered all these and had rightly come to a conclusion, there is no dispute about the proposition laid on and the scope of inquiry under Order 21 Rule 97. And under the guise of an application under Order 21 Rule 97 for a frivolous crimes, the court need not go and conduct an elaborate inquiry, and prima facie the court is satisfied with regard to the nature of claim raised by the objector and rightly dismissed. This court finds no reasons to interfere, accordingly dismissed.
Question number 3. Findings not be treated binding because the main suit is pending.
And any of the observations made by this court are only for the purpose of adjudicating the application before this court. They shall not be construed as an expression of this court, either in these proceedings or in any other suit.
Number 1. Question number 3, serial number 1. A. Krishna Swamy.
So instead of already now for adjourning the matter, court has to think every day 40 to 50 adjourned matters are there in the list, date given matters. So what we'll do is, tomorrow, how many matters are coming in? 60 matters.
Or it could be taken up next week.
No, like, I'll just ask her to see what is the next date when there are little less matters so that we'll complete.
Serial number 17 also tomorrow, please, ma'am. Serial number 17.
Not tomorrow, next week. Someday in the next week, it will be accommodated, all these matters. All the matters, look at the dates. Yes.
Madam, the IA copies.
ಅದ್ಬೇಕು ಯಾಕೆಂದ್ರೆ ಡಿಕ್ಟೇಷನ್ ಅಲ್ಲಿ ಅದು ಎಲ್ಲ ನೋಟ್ ಆಗಿದೆ, ಅದು ಆ ಪಾರ್ಟೀಸ್ ನೇಮ್ ಇಲ್ಲ, ಅದು ಅವ್ರಿಗೆ ಕನ್ಫ್ಯೂಷನ್ ಆದ್ರೆ ಆಮೇಲೆ ಪಾರ್ಟೀಸ್ ನೇಮ್ ಮಿಸ್ಟೇಕ್ ಆಗ್ತಾ ಕಷ್ಟ. ಆಮೇಲೆ ತಗೊಳ್ಳಿ ಸರ್, ಫೈಲ್ ಅಲ್ಲಿ ಇಟ್ಟಿರ್ತೀವಿ. ಅನಿತಾ ಮೇಡಮ್ ಅದು ಒಂದ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಇದೆಯಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಬುಧವಾರ
Hello.